All right, we are connecting. Okay, we are live and on the record.
Okay, if you could hear the cry.
Yes. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and ye shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to the Appeals Court. My name is Amy Blake. I am joined today by Justice Suk-Young Shin and Justice Maureen Walsh. We are your panel for the 6 cases that we are hearing today. The first case this morning is docket number 2020 P0906, Commonwealth versus Luis Pereira. Attorney Leatherman, when you're ready.
Thank you and good morning, Justices. Ben Leatherman on behalf of Mr. Pereira. I do have a tendency to speak a little quickly, which is exacerbated by the Zoom platform. So if I need to slow down, please let me know. It's a bad habit I still have yet to break. So just getting right into it. Mr. Pereira was found guilty after trial of receiving stolen property over 250, under 250, and carrying a firearm without a license. There are 2 docket numbers in this case because the firearm counts were dismissed without prejudice at some point on the original docket and then recharged under a new docket number, but it is a single case and a single trial.
And a single docket number on appeal, correct?
Yes.
Okay.
The first issue that I want to get into is the motion to suppress issue. There was a motion to suppress filed before trial. It was denied. I will note there was an interlocutory appeal filed. It was denied, but not on the merits. It was deemed untimely filed, and that the interest of justice wouldn't be served by hearing the appeal at that time. So even though it was denied, it was not a decision on the merits. So
it seems to me, if I could kind of get to what I think is the nub of the argument, that the piece that I really would like to hear about from your perspective is the information or lack thereof from the CI about whether or not your client had a license to carry.
Right, Judge. So I think that is the main issue. It's not really a reliability or the argument on CI. It's a basis of knowledge for, or really even just a sort of, was there enough information that an actual crime had been committed? Because the information we have here really is someone has a firearm. Here's a description of the individual and the vehicle. His name is Louis. Apparently what was relayed to the detectives, and of course this is based on Detective Lagoa's testimony, he's the one who took the tip from the CI, not the one who effected the arrest. The CI simply said that they didn't believe that Mr. Pereira had a license to carry a firearm. Now, there's no additional information as to how they reached that belief. There's no information that he was, the CI was told that Mr. Pereira didn't have a license to carry. The CI knew Mr. Pereira had, a record that would prevent him from carrying a firearm. It's just that the CI didn't believe that Mr. Pereira had a firearm. And there was some, in the Commonwealth's reply brief.
The CI is a civilian, right? He's not going to have access, or she, to a database to determine whether or not Mr. Pereira has a license to carry. So from a civilian's perspective, why is it not enough to say, I believe he's not licensed?
Well, because that's the crux of the crime. I mean, so we know that just having a gun isn't enough. I mean, it's unclear, again, if the CI knows Mr. Pereira or has any basis for that belief. It could have just been, if the detective asks, does he have a license to carry? Well, I don't think so. That's not enough for probable cause for a stop. And we know that in Massachusetts, just being told that an individual has a firearm is not enough to warrant a stop. That's the Couture case. In Couture, a store clerk saw the defendant have a handgun in his pocket.
Hi, Leatherman, can I interrupt for one moment?
Yes,
Don't we have
Walsh.
more here? Don't we have Detective Lagoa saying that the CI had indicated that the defendant was attempting to sell this firearm?
Yes, but again, that's not a crime. I mean, you're certainly allowed to sell firearms. And if I, in casual conversation with someone, say, I have this pistol I'm trying to sell, unless I make some additional statement that I'm trying to sell it because it's hot or because I don't have a license, I need to get rid of it. I mean, you're perfectly allowed to sell to a firearms dealer and to another individual in Massachusetts, again, as long as both are licensed to carry and it's reported as required by the statute. So simply expressing a desire to sell a firearm is not a crime unless there's some additional factor that, you know, there's evidence that the firearm is possessed illegally or that the sale is going to be illegal. And there's no evidence of that here. We just have.
Why isn't it a reasonable inference that if someone's trying to sell the firearm on the street, that he's possessing it illegally? Why isn't that a reasonable inference?
Well, we don't have the information that he's trying to sell the firearm on the street. What we have is just a statement that he's trying to sell a firearm. Now, the CI could have.
I mean, he was operating in a truck and trying to sell the firearm. I think you can read that as he's trying to sell it on the street.
But that's not, I mean, I don't think that's I think that's an inference that isn't supported by the information given by the CI. Again, the CI didn't say he tried to sell the firearm to me. The CI simply said he's trying to sell a firearm. Now, the detective maybe could have gotten more information or presented more information in the motion to suppress hearing, but they didn't. So what we have is what's on the record.
Let's say we can read the record, the testimony, to mean that the CI conveyed that he saw this person trying to sell the firearm on the street. Why doesn't that lead to the reasonable inference that he was possessing it illegally?
Well, because we don't have that information. I mean, the problem there is we're now inferring something that isn't in evidence. I mean, and we don't have any details about the sale. I mean, if the CI had said, I saw him trying to sell the firearm to another individual, I saw him asking random people if they wanted to buy a firearm. I mean, the problem is we don't have that information. If this was a search warrant application and it simply said this individual, based on reliable information from a CI, has a firearm and is trying to sell it, I don't think that would be enough to issue a search warrant, for example.
Right. Yeah, I agree with you that, we don't have many details about the circumstances of the sale, but I'm just asking, I understand you disagree with my characterization, but I'm asking you to assume that the record can be read that the CI conveyed that the person was trying to sell the firearm on the street. Okay, so I'm adding on the street. I know you disagree with that, but accepting that, why doesn't that lead to the reasonable inference that the person was possessing it illegal? There's something illegal going on.
Well, again, because it's also not, I mean, even if you're trying to sell it on the street, quote unquote, what would that entail? Would it be trying to find, just checking around, seeing if someone wants to buy a firearm? Is it, because again, there's nothing illegal about selling a firearm even on the street. If once you find someone who wants to purchase, you confer and both have a license to carry and purport with the statute. It's not a crime to try and sell a firearm or to even try to sell a firearm on the street unless the sale happens and the parties are, not comporting with the statute regarding sales of firearm in Massachusetts. So, and even if you're trying to sell a firearm on the street, that doesn't necessarily even mean that the individual doesn't have a license to carry. It may mean that they simply don't want to go through the hassle of comporting with the statute. And that in and of itself is not a crime until it happens either, right? So I don't think that just this statement from the CI, this individual is trying to sell a firearm, even if we add on the street, which isn't an evidence, again, there's nothing inherently illegal about that, or that you can reasonably infer that therefore the individual must be possessing the firearm illegally. Because again, it's not a crime to seek to find someone to sell a firearm to. It's not a crime until you don't comport with the statute requiring that the firearm sale be recorded and they comport with the statute on the firearm sale. So I think even if we read that into the CI statement, which again, I disagree with that characterization. I think that was beyond what the CI said. I don't think that's enough for an inference that a crime is being committed. I think this is basically the classic, a tip that someone has a gun and that's not enough, And when we look at cases where there's been an additional factor, that's like the Alvarado case where the firearm in question was a sawed-off shotgun. And the SJC said that was sufficient because, the legislature recognized the dangerous nature of that weapon, and it doesn't really have any uses outside of, military or police use. If we look at Edwards, that was a high crime area. CI knew the defendant by name. He's by himself on a deserted street in the middle of the night with a firearm. He sits along the vehicle with the lights off. There has to be some additional factor that sort of points to public safety implications. That's usually what the
Mr.
plus
Leatherman,
factor is.
Could I ask you at page 34 of your sister's brief on the question about selling a gun on the street? She suggests not what your client said after he was handcuffed, but when he was first pulled over and asked if there was anything that the police should be concerned about with respect to safety, he said he didn't know what they were talking about. Can we consider that as part of the probable cause analysis?
Well, no, Justice, because that's after the seizure's been effected. I mean, he's been stopped at that point and he's removed from his vehicle. Clearly he's seized at that point. So any evidence that happens after the seizure can't be part of the probable cause analysis. And then
the stop has to be lawful, right? Because they ran the information of the operator and determined that the operator didn't have an active license. So at that point, they could have at least stopped the car, right?
Well, they ran the information of the registered owner, but they could tell, it was clearly a company vehicle. It had Tabor Villager modeling on the side. And that information, Protace Woodford, when that came back, that's clearly not Louis, right? That's not the person that the CI said was talking to them. That's a different name. So, and it could have, so that's, they should have determined who was driving the vehicle at that point, because they know, this is not the guy, or they should have gone to the CI and they could have pulled that individual picture.
They had to stop the car first. The stop was, you wouldn't agree that the stop itself was supported by reasonable suspicion?
I don't think so, because when you run that name, it doesn't match the person the name the CI gave them.
Well,
which is
it
Louis.
could be a nickname. Who knows? It's just reasonable suspicion to stop the car. They see the car exactly as described by the CI within an hour of when the information was conveyed. They run the information of the owner. What else can they do? They don't know who's driving the car at that point. They have to stop the car first.
Well, they can. They have the information on the car. They can. Again, I don't think that there's exigent circumstances here that require them. There's not like a public safety issue here that require them to immediately effect a stop. They can go back to the CI. They're in contact with the Detective Lagoa. They can say, "Is this the guy you saw?" And the CI would say no, presumably, because it's apparently not the person they were talking about. We know that it's not this Protace Woodford individual. And then they don't have reasonable suspicion to stop. It would be one thing if the registered owner was named Louis or something that could reasonably come to be a nickname Louis, but Louis is a name.
Accepting for a moment that there's reasonable suspicion to stop the motor vehicle. The statements made by the defendant saying he had no idea, can that be considered for probable cause?
I think it's irrelevant to, well, I suppose in that if we're assuming the stop was reasonable, and then it can go to the probable cause analysis as to searching the entire vehicle, but they search the entire vehicle, and it's not, it's not a quick, the firearm is found in a toolbox in the back of the truck, right? It's in a toolbox in the bed of the truck. So even if it's a Terry stop, a threshold inquiry on public safety, they are entitled only to search what's in the reach of the defendant. And in that case, they exceeded the scope of that search by going into the back of the truck and going through the toolboxes. So even if the initial stop was justified. And even if that statement, I don't have anything, or I don't know what you're talking about, I guess could be, consciousness of guilt or something. Once the officers have determined there isn't an immediate danger and they found nothing in the cab of the truck, they've now exceeded the scope of the search by extending the search, long enough to basically search every inch of the truck to find the firearm in the back toolbox in the bed of the truck. Okay, so I think that's all the questions on the motion to suppress. I will say, I think that even the initial stop wasn't justified in this case because the CI did not give evidence of a crime. And that's the main crux of the argument, that simply saying, the CI basically said, I don't think he has a license to carry. That's not a crime. That's not enough. There's no basis of knowledge for the belief that the defendant didn't have a license to carry. So no evidence of a crime was related to officers. So no stop was justified in this case. Now, moving on to the trial itself, the first issue is—
We're going to have to leave it there, counsel, unless the panel has any additional questions.
Thank you, Justices.
Seeing none, thank you. Attorney O'Neill, when you're ready.
Certainly. Good morning, and may it please the court, Mary O'Neill for the Commonwealth. The court, first and foremost, the Commonwealth would assert that both the motion judge, and it was a different judge for the trial, and the trial judge acted appropriately in the 4 instances that my brother has pointed out. One, which is for the probable cause involved in the motion to suppress.
Attorney O'Neill, what is the closest case that you have on the question of what the CI did or didn't know about the license to carry?
Well, the Davis, Barboza, Handwright all go and use the word believe. My brother is focusing on that word, believe. And believe is not, for an individual such as a CI, to have a belief is not inconsistent with the calculus or the requirements for probable cause. And Davis, Barboza, and Handwright all set that out, that you can believe. And you're looking at circumstantial evidence, you're looking at inferences. What I'm understanding from the defendant's argument
But
is—
are any of those cases about a belief that someone did or did not have a license to carry?
No, but the language that it uses states that the individual, the CI, believed. So in that sense, yes.
What is your closest gun case?
My closest gun case? I don't think I have a closest gun case. I think basically it's just the general argument that, I mean, why would a gun in this instance be treated differently than any other evidence that's presented for purposes of probable cause to stop this individual who's alleged to have a gun? My brother's argument, I mean, versus drugs, versus some other contraband. My brother's argument that—
Interrupt for a moment. It is different. Wouldn't you agree, Attorney O'Neill? If you had the facts as stated, but in this case, confidential informant calls Detective Lagoa and says, I think, Louis is selling drugs and he looks like this and he's in this area and I believe he's selling drugs. And he's driving a car that has this makeup and this is his physical description. Would that be enough for probable cause?
that you believe he's selling drugs, he's in a car of a certain make, and he is of a certain physical description, is very similar to our case here. And yes, I think that would be—
You would say that would be enough?
Yeah.
Probable cause, without any more information. Hey, I believe—
All right. Are we assuming the reliability of the CI, which we do assume?
Right.
In
We
this
have
case?
the reliability,
Okay.
but all we have on the other prong is, here's what he looks like, here's what his nickname is,
Oh.
driving this type of car. I think he's selling drugs. I believe he's selling drugs. That's enough probable cause?
I'm sorry. I thought there was more than I just think he's selling drugs. If there had been some description of the drugs, some description of a transaction, then yes, I'd say probable cause. Short of that, no.
So why is this any different?
Because in this particular case, the defendant is asking the CI and ultimately the Commonwealth to ignore common sense here. So if I may, and legal common sense, if I may, this Louis, who is very specifically described as 5'10", medium build, brown hair, brown eyes, is driving a truck that has Tabor Village Remodeling on the side. And we even have the registration number of the truck. And he's trying to sell a black gun out of the truck. Now, this truck is in the north end of New Bedford. My memory is it's on Acushnet Avenue, but the record will reveal what the record reveals. In any event, we're supposed to say, well, we've got to assume it's legal because there's nothing, because we have no reason not to assume that. We have every reason here not to assume that, because we've got a guy with a 9mm Smith & Wesson trying to sell it in the city of New Bedford in the afternoon from a truck on the side of the street. That's a legitimate inference. That can lead to a legitimate inference. This is not a legit sale.
So is it the crime that differentiates this case? Is it the crime that differentiates this case? Because you just agreed with me with the same information about physical characteristics of Louis and physical characteristics of the truck, including the registration, that the CI saying, I believe he's selling drugs, isn't good enough.
But there's nothing, if I may, Judge, there's nothing more than I believe he's selling drugs. There's nothing to say, I saw him do this. I saw the color of the drugs. We've got a gun. We've got a black gun. We don't know if he's selling alfalfa or if he's selling pot or if he's selling, his mom's contraceptive pills. We don't know. That we don't have any of those specifics, but we have more specifics in this particular case. So I would disagree that I agree with you that there's not enough here. I think there is enough here. If I may.
Anything particular about the nature of a firearm that you think differentiates this case?
The nature of a firearm. Well, they're both public safety concerns, both drugs and firearms. I would suggest that trying to sell a firearm, particularly a 9mm on the side of the road on a street in New Bedford, is a particularly high public safety concern, and thus the response of the police, the undercover officers. So yes, I would say in that respect, you're going to get the attention of public safety officers with the idea of an unlicensed gun going loose. So yeah, I would agree with that there is a difference. But what I would also say here is that the specifics of this gentleman, of the defendant's description of Louis, I mean, I think it's fair to say that among the circumstances, the CI describes his brown eyes. So clearly the CI has firsthand knowledge of what's happening in this case. The CI is on the scene. And the CI is also familiar with Louis and has said a person he knows or he or she knows to be Louis. So all of this information goes into the calculus of, is there sufficient probable cause? And the detail of the information that this reliable CI gave to Detective Lagoa is rather, I would say rather stunning, particularly in that he had the registration number of the truck and remembered the Tabor model.
He didn't give any details about the basis of his knowledge as to his belief that Louis didn't have a license to carry, right? It's just a kind of, I kind of read it as tied to his, the person trying to sell the gun from the truck. But let me ask you, so let's say that the police had reasonable suspicion to stop the car.
Mm-hmm.
At that point, did they not have any obligation to ask some questions to ascertain the defendant's identity?
When they stopped the car, I don't think it took long for them to ascertain his identity, but I think
I didn't see anywhere in the transcript where there was testimony that they asked the defendant any questions other than, is there anything else in this truck that we should be concerned about?
I agree with you.
Okay.
I agree with you, Honor. I don't recall seeing that
So
either.
Did they not have any obligation at that point to ask some questions to determine who this person driving the truck was?
If you mean an obligation in the constitutional sense, no, I don't think so. If you mean an obligation, would it make sense? Sure, I think it would make sense. But I think because I will agree with you. I was a little confused myself where he's handcuffed and I'm not sure exactly who did that and when that happened. but it seems clear that shortly thereafter, he's put in the cruiser. He's separated from the truck. That much is clear. So I'm assuming they did that for safety reasons. Once he's in the back seat of Detective Pereira's cruiser, then Detective Pereira gives him the Miranda. It's a fair inference that at that point they know who he is, but no, I cannot say that on the record it says that's when he was identified. So I can only say when he was booked, he was identified.
Attorney O'Neill, if after they pulled the truck over, and before they got him out, they asked him whether or not he had a license to carry, and he said no, could that be considered for purposes of probable cause?
After the stop?
Yes.
If this is prior to them finding the gun, the probable cause extends to as the scope as far as you have probable cause. So yes, in that respect, certainly. For the initial stop, probably not, but for the probable cause goes beyond that because they had probable cause to search under cast and other cases, for instance, the diamond pattern toolbox and things of that nature. So they didn't lose their probable cause upon the stop. They still maintained it. This time it went to other areas.
Let's say he answered that question. Yes, I do have a license to carry.
Yep.
That was my next question.
Well,
What
they'd have to confirm that. And they'd find out that he didn't. So just him saying that would not be sufficient. That there'd have to be an official confirmation that he did have a license.
So they could detain him after he said he did to determine whether or not he did.
As long I'm speculating a little bit here and I
Right.
hesitate that, but as long as the detention is minimal, then yes, taking him overnight, something like that, certainly not.
But they didn't do any of that. They didn't ascertain his identity. They didn't determine whether he was this Proteus Woodward person. So, why aren't they obligated to do that? I know I'm re-asking my question from before.
It seems logical that they should. And maybe that's why it's concerning, but it's not reversible. It's more,
I mean, aren't they required to either confirm or dispel their reasonable suspicion? So let's say they had reasonable suspicion that the person driving this car was carrying the firearm illegally, but they didn't even do anything to ascertain who he was.
Well, what they were doing was trying to find the gun. So that may have delayed matters a bit. Because again, we will recall that the gun and its ammo, it's 15 rounds, were wrapped in a gray sweatshirt inside the diamond patterned toolbox and in the bed of the car. So that's not going to be immediately apparent to them. So that's going to take a little bit. So I would suggest that the detective's attention at that moment, and I'm not a cop, so I don't know the rules, but my suggestion is get the guy who we think has the gun away from where we think the gun is, and now go find the gun. So that would be.
O'Neill, it's reasonable to assume, even though it's not clearly in the record evidence, that his description matched the CI, right? I mean, in other words, if there was a redheaded woman driving the truck, there would be constitutional issues if they pulled that redheaded woman out of the truck, given the information they had, and searched the truck.
I agree. Yeah. If you wish me to go on to the other issues, I shall do that. But if the court does not wish me to do that, I'll rest on the brief.
Well, I am curious. I mean, you had a civilian witness that was, I guess, overly excited to be a witness. And it's very clear that nobody thought that this was going to happen. In no way do I read your brother's brief to suggest that the Commonwealth was trying to go around the law here, but it came out. And I think the question really for me is, we're reviewing this, right, for substantial risk. The instruction that, was it Judge Cherkansky gave, was different. And it's not clear on the record where that came from. Can you give me some help in that regard?
There's nothing in the record to say where that came from. It was clear that Judge Sharkansky spent a fair to a large amount of time crafting these
Yes.
instructions. And he did request input from counsel, but there's no lobby conference notes or sidebar which explains it. But
And there's no objection, right?
and there's no objection. Right. And time and again, defense was offered, a mistrial if they wanted it. And to the trial count and the trial counsel, defense trial counsel was very well versed in what he was doing. He's a skilled practitioner. And, he let it be known. It's been 4 years since this fellow was arrested. He's not held all this time, but he is held
Right.
sometime. And he wants to go forward. So, to give that instruction at the time, to strike the testimony, and then to repeat all of this and describe why you really, really, really have to ignore the testimony as the first thing you do the day they're giving closing arguments and you're going to give the charge. That's as much curative instruction, I think, as you could give in this circumstance. And given everything else in the case, it doesn't rise to, I would suggest, it doesn't rise to the level of substantial risk of a miscarriage of justice. If nothing further,
Let me check
again,
with the panel. It looks like we are all set. Counsel, thank you both. Very interesting case. The matter will be deemed submitted. Take care.
all right,
Thank you,
thank you.
Justices.
Good morning, Your Honors.
Oh,
May it-
one moment.
Hold on
One
just a
moment.
moment.
Sorry,
Not live yet.
sorry.
Okay, now we are live and on the record.
Okay, good morning again, everyone. For those of you that are watching on YouTube, my name is Amy Blake. I am joined by Justice Suk-Young Shin and Justice Maureen Walsh. We are your panel today for the rest of the cases on the list. The next case we're going to hear is 2020 P0571. It's Commonwealth versus Andre DORZIN. Counsel, I will remind you both that the case is partially impounded, so please be aware of that and follow our impoundment rules. So Attorney Miles, when you get started, the clock will begin.
Sounds good. Good morning, Your Honors. May it please the court. Mary Miles for the appellant Andre DORZIN. Today, Mr. DORZIN comes before you and requests that he be granted a new trial based off of 2 reversible errors. First, that the prosecutor impermissibly argued throughout its closing that the complainant should be believed because she testified in excruciating detail. She lived the rapes in front of the jury, and she did so even though Mr. DORZIN threatened to kill her if she testified against him. Second, I also argue that the 911 tape admitted showing the complainant asking or screaming for help was a reversible error where it was more prejudicial and probative, and it did little, if anything, to establish a relevant fact at issue. If this court would...
You agree that the closing issue is not preserved, correct?
Correct. Yes, I do. So I would agree with the Commonwealth in their brief that both issues are not preserved.
Do you also agree that the basis for the challenge to the 911 call is a different ground here than it was below? And if so, how can we consider that?
I do agree that while the motion for limine, he argued that it was an ongoing emergency and then or not an ongoing emergency, excuse me. And then at trial, before the testimony, before the recording, he said, I object. And then he said, based on the grounds I reiterated before, would mean that it is argued differently on appeal. Therefore, you would have to review it under the substantial risk of a miscarriage of justice analysis. And so if it pleases the court, I'll get to the prosecutor's closing argument. This case is very similar to the 4 cases cited in my brief. Commonwealth v. Durgo, Commonwealth v. Cruz was new, came out after my brief, as well as Commonwealth v. Ramos and Commonwealth v. Beaudry. If I can turn the court's attention to the Commonwealth's closing argument, page 39 of my brief or 48 of trial transcript volume 4. About a page after the beginning of her closing, she says, but now, ladies and gentlemen, 16 years later, she took the stand. And those 16 years weren't her fault. They were the defendant's. She described to you in excruciating detail what the defendant did to her, despite the fact that he called her after he was charged and told her that if she testified against him, she was going to die. Then at the next page, bottom of page 41 of my brief, she said, the prosecutor argues, those are pretty specific details. And why does she remember those details? because she was reliving the rape in front of you as she described those details to you. And then further along in the Commonwealth's closing, bottom on page 44 of my brief, the Commonwealth argues, so I ask you this, where is her motive to lie? Where was it then? Where is it now? And then further along, she says, well, you saw her demeanor as she testified. Something that happened 16 years ago still made her voice shake when she told you about it. It still made her look down in embarrassment and shame. And she was emotional. Think about it. Think about her demeanor, because you can't fabricate that. And why would she fabricate that? What is her motive to lie? And what is Mr. Walkley Toussaint's motive to lie? A boy that dated her 16 years ago, a boy that she has had no contact with, maintained no contact, that he last saw 16 years ago. He even told you the defendant was nice to him. So why would he make up his lie? Why would he continue a lie 16 years later? I would suggest that the evidence proves that there's no motive to lie here. But who has a motive to lie? The defendant does. Once the defendant found out about the charges against him, and after his arrest, he called her and told her that if she testified against him, she would die. I would argue that those remarks are very similar to the remarks found in Durgo, Cruz, Ramos, and Beaudry, where both the SJC and Durgo and the appeals court in the other three cases, except for Beaudry, found that it was error. I would also argue that just as in Commonwealth v. Durgo, there was no other evidence in the complainant's testimony. There was no strong curative instruction, albeit because there was no objection. And I would even go so far as to argue that in one of the encounters the complainant testified to, it could possibly seem implausible, where she said her brothers were in the floor above her when this allegedly happened. Commonwealth points to Commonwealth v. Sanchez, the appeals court case from 2019, claiming that that is more akin to the case we have before this court. I would say that that is very distinguishable. In that case, the prosecutor merely focused on the complainant's motive to lie, while marshaling the evidence as to why, to what she testified. There was no suggestion by the prosecutor that A, she knew more about the complainant's testimony than the jury did, and there was no suggestion that she was credible merely because she testified. There was also important to note that Sanchez wasn't a sexual assault case, and there was much more evidence against the defendant in Sanchez than there was in the 4 cases I mentioned before. Your honors have no other.
Counsel, you would agree, though, that at the trial, defense counsel raised the issue of credibility of the victim, and case law is pretty clear that prosecutor is well within his or her bounds if credibility is attacked, that to connect those arguments with the specific reasons why the jury should believe the testimony, specifically related to the acts of the crime.
Oh, I absolutely agree. I would say that in this case, I make no argument that the defendant didn't attack her credibility. That was the only evidence of the crime. Therefore, that was the only defense available to him. I do not believe the courts say that there is, well, the courts do say that there is a line. And my position is that the Commonwealth crossed over that line when it sought to talk about her embarrassment, when it talked about, she was willing to come in here and testify, even though her father threatened to kill her if she did. She testified in this excruciating detail. She lived the rape in front of you. I would say that verbiage, that rhetoric is more akin to the closing arguments found in Durgo. In Durgo, the prosecutor said at page 1013 of Durgo, goes on for 5 different paragraphs of what the prosecutor said, very similar to what was said in this case. And think about, and at 1014, and think to yourselves, when she sat on the witness stand yesterday and today and was telling you, relaying all the facts of her relationship with the defendant, relaying different sexual acts that she would engage in, do you think that was easy for her? And then further down, did she seem embarrassed at times, maybe a little uncomfortable? And then she subjected herself and answered all the defendant's questions. And then finally, the Commonwealth in that case said, I urge you to consider the whys. Why would she subject herself? I mean, if you look at Cruz, the Cruz prosecutor's closing argument was also similar. Citing at 391, the court says also improper was the prosecutor's suggestion that Jan, the complainant, should be believed because she had come in for no other reason but to tell you about these traumatic events. She has nothing to gain by going through the court process and being on that stand, and it made her emotional. Very similar to the prosecutor's comments in this case. In Ramos, it was just the same along the same lines. The prosecutor asked the jury at 8:26. The prosecutor asked the jury to consider why she would come in almost 4 years later and say to a group of complete strangers, "I was sexually assaulted. I had my period. I was wearing a pad." Why do that? What did she get from that? What motive to lie or fabricate does she have? I argue that this situation is more akin to those in where the prosecutor went over the line to bolster the complainant's credibility. I do not deny that the Commonwealth has every right to try and rehabilitate or point out to the jury the reasons why a witness should be credible. But I argue that she went far beyond that.
Are you saying that it was improper for the prosecutor to bring up the defendant's threats to her if she testified? Why isn't that proper argument?
Because
especially where defense counsel focused on her delay in reporting the crime.
Because the prosecutor didn't argue there was a delay in crime. Well, she did argue at some point that there was a delay in the reporting of the crime because the defendant had told her, had threatened her life, etc. But that's not what the prosecutor said.
Well, I mean, the first part of the argument that you read at the beginning of your presentation, you didn't read the paragraph immediately preceding that section, which is, and so when defense asked you why she didn't tell anyone for 2 years, the reason is sitting right there, the defendant before you. And then the prosecutor goes on to argue that she got on and the stand and testified despite the defendant's threat. So, read in context, why isn't that proper?
It would be my position that those are two different focuses. The paragraph before is focusing properly on why the complainant allegedly or didn't decide not to come forward for 2 years. But when a prosecutor ties in a threat with her willingness to come into court, that's improper. She says she described to you in excruciating detail, talking about her testimony, not for reporting the crime.
Why is that improper? I'm not understanding. So if there's evidence that the defendant threatened to kill her if she got on the stand and testified, why isn't that relevant to her credibility and proper argument?
Because I think that then that goes to all those other cases. We're saying that, arguing that because she testified, even she was willing to testify and subject herself to the court and subject herself to, the embarrassment and the fact that he threatened to kill her, she should be more believed.
But he was also indicted for threatening to kill, wasn't he?
I'm sorry, Justice Blake, I didn't hear your question.
He was indicted and convicted of threatening to kill.
Correct. He was yes, and that's why he was for intimidation of a witness. Exactly, but read in the context of he
wasn't charged with intimidation of a witness?
I thought he was. I could be mistaken, but I thought he was in reference to those statements.
Not from what I see. But if he's charged with threatening to kill,
threat to commit a crime. I'm sorry. You're right. You're right. Sorry. You're right. You're right. I'm sorry, Your Honor. You're right. You're right. Threat to commit a crime. Correct.
So why can't the prosecutor argue the threat then?
Oh, I don't think the prosecutor cannot argue the threat. That's not what I'm saying. I'm saying arguing the threat in relation to her willingness to testify at trial. The prosecutor does and properly argues that he did threaten to kill her if she came to testify at trial. But in here, the way it's worded and the way the prosecutor argues it in conjunction with all the other, what is her motive to lie? What is her embarrassment? She's living the rape in front of you. That in conjunction of when she's describing to you in excruciating detail what the defendant did, despite the fact that he called her, called her after he was charged. She's not talking about a threat to commit a crime. She's talking about her willingness to come to court, even though despite the fact that after he was charged, he told her he was going to come and kill her. I think it's a fine line, but I think it's a line that the prosecutor crossed. Read in conjunction with her latter statements of, she was reliving this rape in front of you. She was embarrassed. What is her motive to lie? What is Wackley Toussaint's motive to lie, even though the defendant never even challenged Wackley Toussaint's motive to lie. That wasn't the defendant's argument at all. So I'm not arguing, and nor do I dispute that there was evidence, according to her testimony, that he threatened her, and that was one of the charges. But saying that he threatened her, but she still came in and testified in this detail, I think is over the line. And that's the defense.
Well, it's proper for the prosecutor to argue that the level of detail in the witness's testimony makes her credible. That's proper, right?
Absolutely, and the prosecutor does do that. I mean, that's what they're talking about when, excuse me, Your Honors. Oh, when they're talking about, why does she remember those specific details? Because she was living the rape in front of you.
Right. So you challenge that as improper, but why is that improper when the argument is focused not on her getting on the stand and testifying, but rather on the level of detail in her testimony?
Because I'm reading in conjunction with her previous statement. I'm taking everything. I'm not trying to parse and parcel about this is specifically improper at this one point. I think taking that overarching theme of this person, despite the fact that her father allegedly tried to said he was going to kill her, and she had no motive to lie. She's on the stand. She's testifying in this detail, living the rape in front of you.
Okay, I get it. So, and then the last section of the argument that you challenge, would you agree that it's proper for the Commonwealth to make an argument based on the witness's demeanor?
Yes, that I do. But again, with my prior statement, Cruz makes, or is it Ramos makes clear that talking about her embarrassment can be over the line. So this isn't just her talking about her demeanor and her being embarrassed and looking down. I would say that in conjunction with all the other overarching statements in the theme throughout the argument is that was more to show, hey, she came to testify and she was embarrassed and she didn't want to do this, but she did this even though he, threatened to kill her. And on the other argument, I'll rest on my brief.
Let me just make sure the panel doesn't have additional questions.
All right.
Nope. Okay, don't see any. Thank you very much. Attorney King, when you're ready.
Good morning, may it please the court. Michelle King, Assistant District Attorney for the Commonwealth. Just from the outset, I'd like to point out that the Cruz case that defense attorney is talking about was not cited in her brief, nor did I receive any notice prior to today that she was going to discuss that. So that's a case that I'm not prepared to talk about today, but I am prepared to talk about everything else. This court should affirm the defendant's convictions because the prosecutor gave a proper closing argument and the 911 call was properly admitted. Commonwealth v. Freeman instructs us that the prosecutor is entitled to address the demeanor, motive to lie, and believability of a witness if it's based on evidence and fair inferences therefrom, not personal beliefs of the prosecutor. I would suggest to you.
We have a lot of cases that say something to the effect of, well, not substantial risk, so it doesn't get reversed, but certain things were better left unsaid. Do you think any of this argument was, I'm not asking you to concede error, I'm not suggesting it wasn't error, but are there areas where you might say that was probably better left unsaid?
I wouldn't say better left unsaid, Your Honor. Possibly phrased a little bit better. I think that the prosecutor, or I suggest to you that the prosecutor did a very good job of marshaling the evidence that was before their jurors and brought that together and created an argument that wasn't necessarily based on a response to the defense attorney's argument, which is one thing that we always urge our trial prosecutors to do, is to make your arguments on their own. That being said, the defense attorney spent a lot of time going through all the reasons why the victim was a liar and all the reasons why she shouldn't be believed, questioning her motivation to testify. And so the prosecutor was entitled in response to that to point the jurors to all of the reasons why, based on the evidence, the victim should be believed. And I would suggest to you that she did a very nice job, in fact, of pointing to specific reasons why the victim should be believed and didn't bring in any sort of personal opinion or belief as to why the victim should be believed, which is, as you know, one of the things that frequently trips up prosecutors is when they go down the path of somehow injecting their personal belief into the situation. And I would suggest to you that the trial prosecutor didn't do that at all in this case. Her argument was based on the evidence that was in front of the jurors, and she properly marshaled it.
What was the purpose of saying that the first complaint witness had no motive to lie?
The defense admittedly did not question the motivation of, specifically the motivation of the first complaint, but that doesn't prohibit the Commonwealth from, on its own, based on the evidence suggesting that that witness does not have a motivation to lie. And the case law is fairly clear on that. What the prosecutor did was she said, what's his motivation to lie? He's here 16 years later. He doesn't have any current relationship with this victim. What's his motivation? And again, that's properly based on evidence. The case came before the jurors 16 years later because the defendant had fled the Commonwealth for a number of years. And the first complaint witness did not currently have any relationship or interaction with the victim. That was his testimony. So based on the case law that tells us the Commonwealth can draw the evidence together and speak to the motivation of a witness, that was a proper argument. With regard to the 911 call, again, that argument made by the defense in their brief is not properly before this court. But even if it was properly before this court, that 911 call was highly probative of the situation that happened at that time. The victim called 911. She can be heard on the 911 tape saying help before it was hung up, and then the police responded. And defense argument at trial was that, this wasn't an emergency situation, nothing happened, nothing bad happened. That 911 call was probative of what was happening in the moments before the police came, after the defendant had threatened the victim that if she said anything to the police, that some harm was going to come to her based on his already having strangled her previously. Defense counsel wants to paint this as a case where it's just the credibility of the witness at hand. But again, we have the 911 call with the victim screaming help. We have the first complaint witness testimony that corroborates, but we also have consciousness of guilt, and the jurors properly received that instruction at trial that the defendants having fled the jurisdiction for 13 years and the evidence of the witness intimidation and threatening to kill her if she testified, the victim's testimony. And we also have her explanation of the pregnancy and abortion. So when you put all that evidence together, I would suggest to you that it's not just a simple he said, she said case, as the defendant would like you to believe. Rather, there's quite a bit of evidence here, even if we look at this under the substantial risk standard. There's more than enough evidence to affirm the defendant's conviction.
Aren't we supposed to do that? Is it your position that we just simply don't review unpreserved evidentiary issues?
Yes, it is, Your Honor. But if you are inclined to, and I cited a number of cases.
Right, but those cases then go on to address the merits of the issue. I mean, let's say that you have a really egregious evidentiary error and defense counsel doesn't object. They could just file it in the context of an ineffective assistance claim, right? So don't we review them for substantial risk anyway?
Agreed, Your Honor. That's your prerogative, but there are a number of cases, and I don't think that all of them then go on to address the issue. But in any event, what we look at is whether or not the trial judge created a palpable error by admitting the 911 tape. And certainly there wasn't in this case. If you look at the relevancy of that 911 tape, it was highly relevant to the issue of the victim's state of mind. And if you look at the Sanchez case, that's directly on point. If there are no further questions, I rely on my brief.
Seeing none, Thank you very much, counsel. The case is deemed submitted. Take care.
Thank you.
Thank you.
All right, we are live and on the record.
All right, good morning again, everyone. My name is Amy Blake. I am joined by Justice Suk-Young Shin and Justice Maureen Walsh. We are your panel for this case and the remaining cases on today's list. The next case is Commonwealth versus Michelle Tierney, docket number 2020P 1029. Mr. Gauthier, when you're ready.
Thank you, Your Honor. Good morning, panel. My name is Attorney Edward Gauthier, and I'm here today representing the defendant appellant Michelle Tierney. She was convicted of assault and battery on a police officer and resisting arrest. Our first issue is the self-defense instruction. The judge in this case made a determination that Ms. Tierney would not be getting a self-defense instruction because defense counsel did not raise that prior to trial. The Commonwealth concedes that was error. Had the self-defense instruction been given, and it should have been given based on the evidence, we believe that a different verdict on those two charges would have come. Michelle Tierney was entitled to an instruction that the Commonwealth must prove beyond a reasonable doubt that she did not act in self-defense. And the Commonwealth cites Commonwealth v. Galvin, 56 Mass Appeals Court 698, for the premise that when this court reviews whether a self-defense instruction should be given, it's not limited to the Commonwealth's case, and it's not limited to the defense case. In this case, the Commonwealth witnesses, officers LaHare and Prezio, testified that she resisted. She kicked her legs while Officer Prezio held her legs and Officer LaHare had her by her upper torso. Ms. Tierney testified that she was being assaulted. She was being physically beaten by two people she did not know were police officers. So we look at the evidence in the light most favorable to the defense, and our position is she was entitled to this instruction. Now, the Commonwealth's argument is that the defense counsel didn't renew the request for the instruction at the close of defense's case, but it would have been fruitless. The judge made a decision that the defendant was not going to get this instruction, regardless of the evidence, because she didn't act. She didn't give notice to the Commonwealth prior to trial. So when it came time for defense counsel to put on a case, he put on a case with his client testifying after being told that because self-defense was not raised prior to trial, the jury was not going to be getting that instruction.
So I find that this case, the facts of this case are and the result is very interesting to me.
It's bizarre, Your Honor.
I understand your argument, but let me tell you where I get stuck. I get stuck when she's found not guilty of ABDW.
It's preposterous.
So you can't, I mean, because to the extent I understand what her defense was, that she thought she was being chased or attacked by these other people that were not police officers, and she was defending herself. The jury rejected the government's case concerning the kick of the police officer.
No, Your Honor. The defendant was found guilty of assault and battery on Prezio, which was the kick, and was found guilty of resisting, which was the kicking, but was not guilty of the lead pipe.
Okay, thank you for fixing that. In my head, I'd love to see this play out in a movie so I can understand it better. But how do you reconcile? Because we often look at what did the jury do, right? We presume that the jury follows the law that they're given. You're saying they weren't given certain law here, but interestingly, she was still acquitted of one of the crimes relating to this altercation. And how do you assess that? What does that tell you?
So I've thought about this a lot because to me, reading the jury verdict, it doesn't make a lot of sense, because to me, the kicking of Officer Prezio and the moving of the legs was the least bad thing she was accused of. And it's frankly the charges for which there's the least incontrovertible evidence. I mean, Officer LaHare testifies she picked up a pipe and beat him twice.
Right, and
He
that
ran-
was the not guilty.
That was the not guilty. The car crash, the leaving the scene was a not guilty. The larceny of the motor vehicle was the not guilty. But then you have these two charges that are really disputable charges are the guilties. And my only thought is that the resisting arrest and the assault and battery on Officer Prezio was fully and completely provable by the testimony of Officer Prezio. So it's clear that the jury may have credited Officer Prezio on the resisting arrest and the assault and battery, but not credited anything Officer LeHare said, because they found that she didn't strike him twice with the pipe and that she didn't leave the scene. Officer LeHare was the only witness to testify to leaving the scene and the assault and battery on him with a pipe. That was rejected. Officer Prezio testified to the resisting arrest and the kick on him. She was found guilty of those two. That's all I can hypothesize, but I don't know. But the verdict, I will agree with this court, did not make a lot of sense to me either.
So the defendant didn't, I'm sorry.
No, go ahead, Justice Shin.
The defendant didn't testify that she defended herself. She testified that she essentially curled up into a ball and did nothing.
Right.
So how does that warrant a self-defense instruction?
I would point out two things. One is that the testimony needs to be taken as a whole, Commonwealth v. Galvin, and the testimony from her was that she was being attacked, and the testimony from the police was that she was struggling. But on top of that, the defense testimony was given in light of the court's ruling that because there was no self-defense instruction or self-defense requested prior to trial, notice that she was not going to get a self-defense instruction. So if she was constrained in her ability to be forthcoming on her conduct with the police in that instance, because the court had ruled that regardless of how the evidence was going to come in, she was not going to
So
get the instruction.
she tailored her testimony based on an evidentiary ruling of the court?
If she's told that she cannot get a self-defense instruction for the assault and battery and the resisting arrest, it would have been unfortunate for her to include testimony that she kicked the officer. She would never testify to that knowing that she would not get the instruction.
Well, it's not just an omission. I mean, her version of the story is she was sitting curled up in a ball doing nothing. I mean, that's her testimony. I don't really understand how the court's earlier ruling affects that at all.
Well, the court's earlier ruling was that she was not going to get a self-defense instruction. So if her testimony was going to be that she struggled with the officers in self-defense, she could no longer give that testimony because she's no longer getting the instruction.
So
So
then she
Attorney
lied
Gothier-
on the stand?
Oh,
About
I'm
what
not
happened?
saying that. I'm not saying that she lied on the stand.
Attorney Gothier, let me understand this. So what you're saying is that even defense counsel's opening statement about her actions were somehow skewed because of the judge's decision not to allow a self-defense theory?
When defense attorneys give opening statements, they do so very cautiously because it's prior to the introduction of any testimony. And two things, you don't know what the witnesses are going to say, even the Commonwealth witnesses, you don't know what they're going to say. And in any event, no competent defense attorney ever tells the Commonwealth in advance of them presenting their case what their theory of the case is going to be. So there was no reason for defense counsel to stand up and reveal to the Commonwealth what they were planning to do at trial.
So my question though is, are you suggesting that the entire trial, including counsel's opening statement, was somehow impacted by the judge's refusal to give a self-defense instruction?
I would say the only thing that was possibly, and I can't say for certain what was impacted, but the only thing that was possibly impacted was the decision by defense counsel on how to present the case. Because the decision was made after the Commonwealth rested that there would be no self-defense instruction. So then
That's my point though, right?
Right.
So the opening statement of counsel would be very different, wouldn't it?
If defense counsel knew in advance of trial that there was no self-defense instruction, he may have tailored his opening statement based on that knowledge. Very true.
And the instruction about excessive or unreasonable use of force,
Right.
you say is not enough to overcome this error that you
I would
claim.
say yes, because the standard for self-defense shifts the burden to the prosecution to prove beyond a reasonable doubt that there was no self-defense. It's not just a statement that you can analyze the police's use of force and the defendant's reaction to that use of force. It really shifts the burden to the prosecution to prove that the defendant's conduct of kicking her legs essentially was beyond a reasonable doubt, not self-defense. If there are no further questions on issue 1, I'd like to briefly talk about issue 3, the tailoring of the testimony. The Commonwealth disagrees with the standard of review, but I would point out on page 24 of my brief, I do point out that the defense counsel did object to closing, asked for a curative instruction, but did so on grounds that are slightly different than the grounds that we have on appeal here. He pointed out that maybe some statements about the defendant's story being ridiculous or improper, but we're focusing on the fact that defense counsel, the prosecutor essentially said that defense counsel, the defendant could sit there during trial, listen to all of the trial testimony, and then tailor her entire story to what she had heard. And based on her trial testimony, that's arguably what could have happened. But in Commonwealth v. Alphonse, which I cite, the Commonwealth simply is not allowed to comment on the ability of the defendant to observe all of the witnesses and then tailor her testimony. And the Commonwealth does say that, yes, she made an example. One of the examples is that she heard the owner of the car testify to something and then maybe tailored her testimony to that and resulted in not guilty. But the statement that she tailored her testimony is equally applicable to everything the defendant said on the stand. Everything the defendant said on the stand was in essence an attempted refutation of everything every Commonwealth witness said.
And I don't mean to sound like a broken record, but I think I'm going to. Again, when I look at the jury verdict, the claims are somewhat belied by the result. The jury was discerning.
The jury was interesting. It was definitely interesting. I look at the verdict and for each not guilty and each guilty, I would have presumed the opposite result, to be honest, based on the evidence that I heard. But we are left with their verdict, and they did come to an interesting verdict, not finding her guilty of the pipe and the stolen car and the leaving the scene, and finding her guilty of the struggle, basically on the back of the equipment. That was where they found that her criminal liability lie was in that few seconds of struggle, not with anything else that happened that night. So it is difficult to say. They requested a Tui Rodriguez instruction. We weren't in the jury room. We never are. So we really have no idea what was going on. If there are no further questions from the panel, the defendant would rest on her brief.
Seeing none, thank you very much, Attorney Grester. We will now hear from Attorney Offstring.
Good morning. May it please the court, Susan Offstring on behalf of the Commonwealth. First, for the record, at one point, Attorney Gauthier's argument, I believe a response to Justice Shin, my internet must have cut out. Everyone was frozen and I didn't hear some that was said. So if I don't address something, that could be why, but I got a notice that my internet is spotty, so I apologize.
Oh, geez, I'm sorry about that.
It's okay. The evidence at trial from the beginning to the end was that this was not a self-defense case. The defense asked for the instruction as
almost part of his instruction on the resisting arrest charge. And at that point, the judge and both defense attorneys, as I noted in my brief, mistakenly said, well, no notice was given. But it's more than that. The judge did say, well, I don't see any evidence of self-defense, number one. Number two, he invited both before the defense testified and after the defendant testified to revisit the instructions. So it's the Commonwealth's position that had the defendant truly been seeking a self-defense instruction on the resisting arrest charge, he had an opportunity to present it and argue it to the judge. I think it's speculative for defense counsel to say, well, he just wasn't going to give it because there was no notice. The judge at least twice said he would revisit the instruction. Defense counsel never renewed his request for self-defense, said he was content after the final charge. And I think it's pretty reasonable to infer why defense counsel didn't raise it again. It's because he had poked enough holes in the Commonwealth's case in terms of what evidence was missing. They didn't bring in the steel pipe. They didn't take surveillance video footage from the nightclub. So he had poked enough holes in it. The defendant took the stand. She never claimed, and this is important, which I cite in my brief, her defense was not self-defense. It was, as I believe Justice Shin pointed out, she was curled up in a ball. She didn't even know it was a police officer at first, and that first officer was LeHare. And Justice Blake, as you and defense counsel have tried to figure out how the jury came up with it, I too did the same thing. And if you really look at the evidence, including what the defendant testified to, it was my theory that she did not believe there was a police officer involved until the second officer, Prizio, got there. Now the jury concluded she knew there was a police officer, and she continued to struggle. And that's why for that and other reasons, they didn't convict her on the 3 charges, but at least as terms of Prizio, and of course, the resisting arrest, we don't know which officer it was, but I think I infer that the jury saw that what she did once Prizio got there, that she now knew she wasn't dealing with this man, Peter. This was a police officer, and that's why she was convicted on those charges. But again, Mr. Commonwealth's position, as I cite in my brief, that the primary defense was not self-defense from the opening to the defendant's testimony to the closing. This was strictly, Commonwealth didn't prove their case beyond a reasonable doubt, and that this was not even a case where I didn't do it, but if I did do it, it was self-defense, which some of the cases I cite, that was the defense. This was just nothing about self-defense. It didn't happen the way the Commonwealth says it happened, period. So whether it was a preserved error or a substantial risk, to me, it doesn't matter. There was no prejudicial error, and the verdict should be affirmed. Getting to the third argument, the Commonwealth concedes in the brief that it was wrong for the prosecutor to suggest that the defendant sat through and heard this testimony. The one I saw most objectable, and I think that was what Attorney Agathia was mentioning, was that she tailored the testimony to say that this man Peter had an accent, kind of suggesting that when the car owner also had a friend who had an accent, that was tailoring her testimony. I agree and conceded in my brief that was improper, but in light of the totality of the evidence, the totality of the judge's instructions that closing arguments are not evidence, and in light of the outcome that she was acquitted on 3 of the 5 charges, I don't think it was a prejudicial error. And for those reasons, I would ask that this court affirm the convictions.
Does the panel have any additional questions? Seeing none, you're welcome to rest on your brief for the remainder of your argument. Counsel, thank you both. The case is deemed submitted. We are now going to go into a very brief morning recess, and we will be back with the Smith case. Thank you all.
Thank you.
All right, we are live and on the record.
Okay, good morning. Just again, for those of you watching, my name is Amy Blake. I am joined today by Justice Suk-Young Shin and Justice Maureen Walsh. We are your panel for this case as well as the remaining cases on our list today. The next case that we are hearing is docket number 2020-P1180, Virginia Smith and others versus City of Westfield and others. Mr. Stewart, when you are ready.
Good morning, Your Honor. John Stewart for the plaintiffs' appellants, if it please the court. The Smiths have appealed, the plaintiffs have appealed from an order of Judge Mason that we believe is erroneous. The facts of this case are that Ponders Hollow was a property in Westfield, and at a certain point in time, the City of Westfield decided that they wanted to build a school at Cross Street, so they needed a substitute property to meet their obligations under the Land and Water Conservation Fund appropriation that they were receiving and other obligations. So they decided.
Can I ask you, I mean, we've definitely familiar with the record. I know that we've read the appeals
Let me
court
jump
case,
in at
the
a further
SJC case. I don't know if this is considered round 2 or round 3 at this point, but you would agree that the city is not looking to build the school, right?
Correct.
So is any part of your claim now moot?
There is one very small part of it, and I think it's on page 36 of the appendix. About 5% of it is moot, Your Honor. There is a request. Here we go, on page 36, prayer B at the top. So
the city ordinance piece is, you agree, is moot?
Well, hold on. They're saying that they have to submit that to LWCF. So that little tiny, well, let me see if I'm getting the right thing here, Your Honor. I guess I'm telling you that there's at least 95% of the case that is not moot.
But if the city has, and I'll confirm this with Mr. Garber, but if the city has abandoned its plan to substitute Ponders Hollow for Cross Street, it seems to me that your clients have received the result that they were looking for. So what actual, putting aside the question of mootness for a moment, I am going to come back to it. What actual controversy remains?
Your Honor, let me rewind what I said about Order B.
Okay.
Let me tell you what is still in controversy. The City of Westfield violated their own ordinance that required, when they transferred property from the fire department to the conservation, or to the Parks and Recreation Department for conservation purposes.
Because they didn't submit it to the planning board, right?
Correct.
Okay, so let me assume for the sake of this question that I agree with you. I don't know that I do, but let's just assume I do. So what? They're not moving forward.
Well, we need to void that transfer. Because it's illegal under the mandate.
What's the harm to your clients? What's the controversy? How are your clients being hurt?
It bleeds into the second ground that this appeal is based on, and that is that Ponders Hollow is Article 97 protected under the Mass Constitution.
A moment, Attorney Stewart, and I'm trying to say this in the kindest way that I can phrase this question. How are you here?
We are asking for two.
Don't have any other inherent interest in this particular transfer that didn't go before the planning committee, right? Than any other citizen in the city of Westfield.
Your Honor, I think you're getting to standing, and we've got basically 2 or 3 ways that we have standing here. One is the 10 taxpayer statute. There are obligations about to be incurred. There are
What are the obligations that are about to be incurred?
well, under the obligations that the city undertook in this case, they were to do certain things immediately in March of
No,
2015.
that's the failure. You're challenging their failure to do something, but the 10 taxpayer statute that you rely on is a restraint on appropriations, and I don't see how that applies here.
Your Honor, it's all about incurring obligations, and also we have under the public rights doctrine, we have a right, a citizen in this type of situation where a public official is violating the law, and under the mandamus statute, these plaintiffs have a right to, just like in the Smith case.
You still need to show concrete injury, and I'm still not seeing what that is here.
Your Honor, the city of Westfield transferred this property in a not legally sanctioned way. This was a park. They dedicated it 3 different ways. I can point out the pages in the appendix where it was dedicated 3 different ways. And then it was supposed to be conservation land that was going to be developed. Certain things were going to be done immediately. Other things were going to be done within 3 years. And the fact is,
so your injury, you're saying your injury is the city's failure to develop this property as a park?
that is among the, absolutely, Your Honor.
Oh, well,
And-
that seems to me to be contrary to your claims. I mean, I'm just very confused because I see the purpose of this complaint. The entire purpose of this case was to void the transfer of the Ponders Hollow property to the Parks and Recreation Department so that the city does not have a replacement site for the Cross Street Park. In other words, the purpose of the complaint was you don't want a park here at Ponders Hollow. And now you're on appeal saying they dedicate it as a park and now it's entitled to Article 97 protection. I mean, it has to be pled in the complaint.
Your Honor, the case evolved. Obviously, when the suit was brought, they were planning on putting a school on Cross Street, and that changed during the course of this case. I freely admit that the pleadings really don't reflect the issues in controversy. But by the time
But that's all. I'm sorry.
I'm getting there, Your Honor.
Okay.
If you just give me one more sentence or two. When the case went to Judge Mason had no problem picking out the two issues that we're up on appeal on now, which is the following the Westfield Ordinance and Chapter 97, Article 97 protection. Those are fairly the issues that the parties with the consent of both parties, nobody objected to that being the issues in the case. And that's what Judge Mason issued a ruling on. I agree with Your Honor. It would be better if we had a complaint that was updated after all these things happened. But the fact is, and many of them are alleged, certainly the failure to adhere to the ordinance was fairly set out in the complaint. And I believe that Article 97 was as well. Those are the issues.
Two questions.
Yes, Your
First,
Honor.
what is your best mandamus case?
This case is governed by Smith 1, the SJC decision in 2017. What happened in Smith 1 is they decided that the Cross Street Playground, it really hadn't ever been dedicated right. But the fact is it got LWCF funding and EEA recognized that was enough for Article 97 protection. And the SJC said that was the fact that that property was protected under LWCF. That was the determining factor in it
But
being
it's your
considered
position
dedicated.
That the transfer from the fire department to Parks and Rec was void, right?
Correct.
But isn't it also your position that Ponders Hollow is a park?
Yes, Your Honor.
How do you reconcile that?
Your Honor, it was supposed to be brought to the planning board for report and recommendation as part of the transfer. The whole point of of the transfer under the statute, under the city ordinance, is that it's going to have planning board input. That's why it never got developed, because they never brought it to the planning board to do the things they promised to do.
Do your clients want Ponders Hollow to be a park or no?
We do.
So if
how
you
are
had
you
my
harmed?
pen and you could write any order stemming from your complaint, what would it say?
It would say that the transfer is void, and it would say that the land is protected under Article 97 of the Massachusetts Constitution.
How are you harmed by the transfer? I'm not understanding this at all. How are you harmed by the transfer to the Parks and Recreation Department?
Because of the way they did it, it didn't go to the planning board for a report and
So you want it to
recommendation.
go back to the fire department?
As long as it's Article 97 protected, that would be fine. Your Honor, I haven't gotten to the part of my argument where I tell you, and let me just give you one bit of it. We believe this case is governed by Smith 1. And the SJC said the determining factor whether a property is protected by Article 97 is whether
What's the pin site? Where are you right now in Smith?
I have it right here, Your Honor.
I have the case in front of me. I just want to know where you're reading from.
78 Mass 49, and the page I'm talking about is basically the last
What?
page.
Why don't you come back into the screen? Because I think we're all having trouble hearing you.
Yes,
What
and-
page?
yeah, I'm looking at the different sites. So I believe it's page 64. So it'll be pretty much the last page. In any event, it says once it became dedicated, that is Article 97 protection.
The
And the
Cross
fact,
Street Playground, not Ponders Hollow.
Your Honor, what we're saying is that the judge made an error here. He said, in his opinion, that the fact that it was LWCF protected was a factor in whether it is deemed dedicated, okay?
Well, if you're reading from Smith 1, Smith 1 says the Cross Street Playground, however, was dedicated as a public park by the city under this standard and therefore is protected under the prior public use doctrine and Article 97.
Correct.
That's Cross Street. That's not Ponders Hollow.
I'm going down further in that paragraph. Although we consider the totality of the circumstances, the determinative factor here was the fact that it was under LWCF.
But among all of the other circumstances, and the first paragraph of the opinion says, a city dedicates land as a park when there's a clear and unequivocal intent to dedicate the land permanently as a public park, and where the public accepts such use by actually using the land as a public park. The Cross Street Playground was used as a public park for 60 years.
Correct.
And the court said it did not have to decide whether that alone was enough to confer Article 97 protection, because then once the city accepted those federal funds, that was the tipping factor.
Right.
They were not
Right.
saying that was the only factor. So here you have a property that's never been used as a public park. Is that right?
Because of that, they breached their obligation to the US government.
Regardless, I mean, it has never been used as a public park. So I don't
No.
see how this fits in any way into the standard that the SJC laid out.
Let me get you there, Your Honor. There
Okay.
are three different places that the city of Westfield dedicated this property on page 92 of the appendix, on page 132 of the appendix, and on page 139 of the appendix. And actually, one of the conditions that to allow this property to be substituted for Cross Street, where they wanted to build the playground, was that they had to dedicate it and had to protect it under LWCF. Now, Your Honor, in Smith, in the Smith decision, I was just talking to Justice Blake about two different places in that opinion. They use the word irrevocable. Once a property is put into LWCF protection, that is irrevocable. So the fact is the fact that LWCF took away their protection after the deadline already ran, the 3-year deadline to turn this into a park, it doesn't matter. The word irrevocable means that once it is dedicated, and like I told you, it was dedicated in 3 different places in the appendix, that's irrevocable. It's protected. There's no going back from that. And to prove the point, in Smith 1, the Cross Street Playground, remember, they removed it as part of the swap that's involved in this case. They removed Cross Street from being protected and then put that protection over on Ponders Hollow. However, the SJC held in Smith 1 that Cross Street was still protected, even though the LWCF had been taken away. So I think that proves our case.
But so is your goal to have the city construct a park at Ponders Hollow?
Among other things, Your Honor, we think that they should meet their, first of all, it's Article 97
What is the
protected.
obligation, though? What I don't know what you're asking, not us, but what you were asking the lower court to do.
We're asking to recognize that this land is Article 97 protected and that the transfer was void. Now, if the transfer goes through the usual channels, it will go to the planning board.
Let's assume that it went through the planning board, they gave it a gold star. It was Article 97 protected, then what? Then what do your clients want?
Whatever the planning board recommends.
So if the planning board says no park, they're fine with that.
They could accept that.
And if the planning board says a park, they're fine with that.
They are very confident, Your Honor, that there will be a park there if it goes through planning.
What if they said a school?
There is no authorization for a school, Your Honor. And by the way, it's Article 97. There would have to be 2/3 of the Massachusetts legislature to vote to put a school there.
All right, let me see if the panel has additional questions. Okay, I don't see any. Thank you, Attorney Stewart.
Thank you, Your Honor.
Good morning, Your Honors. As you know, I'm John Garber, Assistant City Solicitor for the City of Westfield.
Your volume is a little bit low.
Let me move in. I'm told I have a weak mic. Is that a little better?
That's much better, thank you. Can we just start where your brother left off?
Sure.
I'm still confused as to what the plaintiffs seek for a remedy. But putting that aside for a minute, do they have standing?
They live across town from Ponders Hollow. I think that's pretty clear from the appendix record.
So that the 10 taxpayer statute gives them standing?
Well, I don't believe it does. I think it's mooted, as Your Honors were discussing a little earlier, because clearly the goal of the complaint is to stop the construction of the school. But I think mootness arises in 2 different ways. One is the decision not to have the school, not to build the school, mooted much or almost all of the relief sought by the plaintiffs here. But there's another thing that moots a lot of what's happening, and this was coming up at the end of counsel's argument. What happened was they went to the federal government when they needed a part of Cross Street Playground and said, we will swap that restriction and we will put Ponders Hollow in its place, which the government approved. The federal government approved that. So that was how Ponders Hollow came to have that restriction. And the application is in the appendix. It's pretty, but I think what moots the rest of plaintiff's claim is that subsequently, when the school plans were abandoned, the city of Westfield went back to the government and said, can we reverse the Ponders Hollow restriction, put it back on Cross Street? Government said yes. That's in the record.
But your brother says that that does not void the Article 97 status. You say it does. What do we have for authority either way?
Well, if shifting away from mootness, if the question is Article 97 status, I think our argument has always been, if the federal restriction put on Ponders Hollow at the city's request, if that was the basis for Article 97 status, then that status should disappear when the federal restriction is removed, which it was.
Do we have any cases that say that either here or across the country?
Well, I think if you read Smith and you look at Smith 1 and you look at the totality of the circumstances, and really that was the substance of the summary judgment record, which Judge Mason ruled on, the Article 97 status was, I think, below seen as basically the argument looking at Smith, and was there the intent, the unequivocal and clear intent by Westfield to dedicate Ponders Hollow as a park. I think that was seemed to be well, certainly it was the issue that plaintiffs have consistently raised. So that was the one that below we addressed in the record. And our position is the Superior Court Judge Mason, got it right when he said, no, there isn't evidence in this summary judgment record of Westfield's clear and unequivocal intent to dedicate Ponders as a public park, or as.
Do you say that Article 97 protection never attached to Ponders?
Yes, yes. And the reasoning is the reason Ponders was swapped in under the federal restriction scheme was to build a school. And if you look at the application for the swap, it's at Appendix 87. The city describes why it's asking for Ponders to be designated with the restriction in lieu of the original Cross Street. And the answer is, we're trying to build a school. Our schools are obsolete. We have overcrowding. We have to build a school. This is the way we can do it. There are no alternatives. This is what we must have. And that then meant that in terms of making some declaration of intent that this be a Article 7 property, everything was contingent based on that purpose, on the school getting built, which is a difficult process, very difficult, many obstacles. It was thwarted a number of times here, and it never was built. It was unsuccessful. So under Smith, which requires essentially unconditional, irrevocable intent to build, to dedicate this land, the plaintiffs who had the burden of providing evidence of that intent failed to, because basically they rely on the application. The application basically said, please, we're trying to build a school, and please let us swap in this land. And that is not, in the city's view, a declaration of the kind of intent that Smith envisioned for Article 97.
What is Ponders Hollow? What is there?
It is open, passive recreation use. It doesn't have ball fields on it. It's just land.
Does it abut the fire department?
No, not that no, I don't believe so. And if I can go just one step further, Your Honor, and get past Article 97, I think.
Well, before you move on, Counsel, can I just ask you one question? Is your brother correct that you did not raise any objection below to this Article 97 issue being raised in this case?
We dispute the status.
No, I understand. But in terms of what's at issue in the case, did you object to that being decided by the judge on summary judgment? Because it's not in the complaint, right? So, but you didn't object to it being decided by the judge.
I think the answer is no, the city did not object. And the reason for that is plaintiff always had two claims. They said, here's this local ordinance that says you have to go to the planning board before you take final action with respect to the location of a new public park. So that's always been the claim. But the plaintiffs, I think, have pretty consistently said Article 97 status makes this a public park. That's always been their argument. So to the extent on summary judgment, they made that argument. And I believe it's the first issue they raise here. If I remember the way they designated the issues, they said improper denial of summary judgment and Article 97. So I guess we have never, because plaintiff has put the case in that posture, we have always responded accordingly. And so I can't claim surprise that that's an issue being raised by council. That hasn't been something we thought. But if I can go further than Article 97, and I think ultimately our argument is one of local control, that there are three levels of land restriction here. One of them is the federal. Under the federal program, LWCF, I believe the language is, it has to be maintained public outdoor recreational uses. That's the federal language. That's what happens when you have that kind of a restriction. That's a federal law based on funding. Article 97, Massachusetts Constitution, land dedicated, and it's a long phrase, but essentially conservation purposes, I think is how the Smith Court summarized it. So you have the federal level, you have a state level, and then you have Westfield, which is a municipality under MGL 45, sections 3 and 5. They're authorized to create park commissions, and those park commissions are authorized to, and I'm quoting, lay out and improve public parks under section 5, and also make rules for their use. So ultimately, our argument beyond 97, Article 97, is to say whether the ordinance was complied with here. And that's really always been their complaint, that it's an illegal transfer because it violated this ordinance. That's a Westfield ordinance, and it refers to a public park. And Westfield has its own rules and its own ordinances that govern public parks. And we cited them. 1166 in particular actually is a Westfield ordinance that lists the public parks. It says, here they are. These are what we mean when we say public park. And in order to make something a public park under those ordinances, you have to amend that and add a park. And I guess—
And Ponders Hollow is not in that list.
No, it's not. And, you know, I guess I would also say that based on these different categories of land restriction, federal, state, and then municipal, just because something is restricted to federal use under the federal rules or under the state, under Article 97, that doesn't make it a public park for purposes of Westfield ordinance. And really, that is what this case is.
Well, you're sort of shifting, I think, a little bit to your preemption argument, which I have to tell you, I'm struggling with, because you would agree that Massachusetts can provide more protection for public lands without running afoul, right?
Yes, yes.
All right, so is there ever a circumstance where Article 97 is preempted?
No, not Article 97. Not Article 97. Well, I would say yes. If Article 97 is the sole basis for a claim that land is, I don't know, a public park, or the argument plaintiffs are advancing, by virtue of the reversal, which is authorized by the federal government, the city of Westfield sought to reverse the status. So I guess what we're saying is, if Article 97 attached by virtue of the federal restriction, right? When we did the swap, Ponders suddenly has a federal restriction that it didn't have.
And Massachusetts would have to abide by that.
Well, if that created Article 97 status in Ponders, when that swap was made, and it otherwise wouldn't have had that status.
Right.
And when Westfield goes back to the federal government 3 years later and says, couldn't build a school, please reverse that designation, reverse that restriction. I would say in that case, if the only reason it was Article 97 to begin with was the federal restriction, which I believe is one of the arguments plaintiffs makes, and I think they made it today, then when you reverse that federal restriction, Article 97 status no longer adheres. That would be our position. Because otherwise, you're putting an obstacle in the federal scheme that promotes flexible land use. Municipalities have to do a lot of planning and about what to do with the land they have. This case is a great example of needing flexibility to do different things with land. The federal program permitted Westfield to do that. And if state law thwarts that purpose, at least as far as the federal restriction goes, I think it would be clear.
Can I ask you, I'm sorry, part of the complaint dealing with the ordinance. I'm just having trouble figuring out what the practical effect of any ruling we issue is going to be. So the complaint says declare void the transfer of this property from the fire department to the Parks and Recreation Department. So let's say we did that. I mean, would the city object to that?
Well, we would, because we'd have to undo it. We've already done it. We think it was legal. And yes, we would object. If the question is really, isn't that an administrative matter that's fairly modest in scope and perhaps not very difficult? That's a different question.
I mean, what's the practical effect of the transfer right now? That's what I'm not understanding.
Well, I don't want to speak for council. I think what they're saying is the transfer was before the parcel was transferred from the fire department to Parks and Rec, it should have gone to the planning board. I understand that to be what they're arguing.
No, I understand their argument. I'm just trying to understand in real life, what is the practical effect of this vote right now, today, in real life? The fact that it was transferred from the fire department to the Parks and Recreation, how does that affect anybody?
I don't think it affects anybody. I don't think it has any effect.
So why would the city even object to the vote being voided, just as a matter of principle?
Well,
well,
we believe our behavior was lawful. So,
okay, I
yes.
get that, but it doesn't. But there's no practical effect that this transfer has right now on anyone. Would you agree with that?
Yes, I would.
Okay.
It hasn't changed. The transfer by itself hasn't changed the status of the property. What obviously it's part of a much larger picture where you had a school planned and then there was a swap, and so the restriction was imposed and then unimposed was taken away. So there's a whole stream of events there. But as far as the transfer from fire to parks, it hasn't made any difference. The land's still there. I think to this day it's a passive recreational use. I think that was in the plaintiff's brief. That's the current status of Ponders Hollow.
So
I don't think it would make any difference.
can I just ask you to go back and clarify for me which claims you say are moot?
I would. It's a good question. It's not easy to answer quickly. I think the Judge Mason, in his decision, started with mootness, and
that had to do everything with the Cross Street Playground, right? That's not sort of in the mix anymore.
correct. Anything that had to do with the school, funding for the school, don't fund the school, all those counts are gone.
And do you think that the issues with respect to Ponders Hollow are moot, or do you think that there's no actual controversy, or do you think that the plaintiffs don't have standing, or do you think something different than that?
Well, I'm tempted to say all of the above, but I think, as I said earlier, the mootness of the plaintiff's claims comes from two sources. One is the abandonment of the school plans at Cross Street. But then I think what really renders everything moot is when you reverse the federal restriction on Ponders Hollow and put it back onto Cross Street where it originally was. I think that reversal moots the plaintiff's case, because now Ponders doesn't have the federal restriction. There's, we would say, no argument any longer, even potentially, that was Article 97. Because I think what plaintiffs say is the only reason it was Article 97 is because of the federal restriction. Our position would be, once the restriction is revoked and eliminated, there goes Article 97, if it ever existed. We dispute.
I get you. Okay.
So there's nothing in this record about what the city plans to do with this property, right? It's just sitting there right now.
Ponders, yes, that's correct.
Yeah. Okay.
That's correct. I believe plaintiff's brief actually has a bit somewhere where they went on to the site, the city site, and it's identified, if memory serves, a passive recreational.
Passive recreational.
Something, yeah, something like that. And that's all that's going. That's all that's in the record about Ponders Hollow. Beyond, after the federal restriction was reversed, which happened, I think, in 18.
Let me just check with the panel. I don't see any other questions. Gentlemen, thank you both. Obviously, it's a tricky case and we appreciate your arguments. The case.
Are we?
Not yet. I'll let you
Okay.
know.
Thank you.
We are live and back on the record.
Okay, good morning again, everyone. Again, my name is Amy Blake. I am joined by Justice Suk-Young Shin and Justice Maureen Walsh for this case and the remaining cases on today's list. The next case we're going to hear is docket number 2020 P0140, John Farnsworth versus Cynthia, Zurgot-Farnsworth. The case is partially impounded. Remind both sides that you're permitted 15 minutes of argument with no rebuttal. The time will begin, Ms. Farnsworth, when you start. So take it away.
Good morning, Justices. Cynthia Zurgot-Farnsworth. I would like to share with the court that the issue here is due process violations. This case is not new to due process violations. And in fact, in 2000 and I believe 13, there was a single justice that found a violation of due process, and we turned the case back to Worcester for additional argument in cases. Basically, my position today is there's due process violations on a hearing. Well, maybe perhaps I should give you a background. There was an initial complaint for contempt filed by Mr. Farnsworth, and that was in 2014. There was a order issued on 129 that said 129.14 that said a payment of $1,000 a month, $5,000 up front. Unfortunately, I couldn't make that payment. That order is at RA volume 220. I filed bankruptcy on 4/21/14. The reason I did that is I believed another court, such as the bankruptcy court, would be able to better process a situation of determining what assets I have or I don't have to make the payment. So through the case, it was ultimately resolved on 3/13/15, and the bankruptcy court found that I had no assets to make any payments or any distribution. That's at RA volume 2-22. However, in this situation, it was remanded back to the lower court for further disposition. Basically, there was not a lot of action after that, but then on 6/12/2014, Attorney John Anastasi was actually appointed a receiver as Eugene O'Donnell had already completed his receivership, and that's in volume 3, pages 63 and 64. Basically, there was a cause of action that was happening down in the Florida bankruptcy court on a corporation that I owned some shares at one point in time. There was a distribution of funds in the amount of $266,988.41 as a settlement to Mr. Farnsworth's claim that he was entitled to money based upon the divorce from that asset. That just sort of stayed there in limbo. And then Mr. Farnsworth did file again a motion for, a complaint for contempt. In my answer to the complaint for contempt on 1/16/2017, I asked for an evidentiary hearing, a full evidentiary hearing. And that was at RA volume 2-18. I also asked for a motion for accounting volume 2-26. And at that point, there was a hearing on May 1st of 2017. At that time, also the record reflects that I asked for a full evidentiary hearing and I asked for an accounting. I also pointed out to the court that there was this additional $266,988.41 that was received by Mr. Farnsworth after the last hearing in the probate and family court on a complaint for contempt. So again, I was asking for a hearing to be had on those issues. The judge, and again, I asked for it in the transcripts. I believe I might have said volume 6, page 12. There was the hearing, and it was a very short hearing, and Judge Meager took it under consideration. She did issue an order also on 5/1 that said that she found, despite the fact that the bankruptcy court said I had no assets, that I intentionally failed to pay the sum under a judgment, and that, but she did say she found insufficient proof that I had assets at the time to make the payment. Obviously, she confirmed it was a divorce situation. She doesn't condone my behavior, and that she was going to issue an execution in the amount of $989,160,000 pro non-tunc back to 1/29/2014. I filed a motion for reconsideration, and Justice Meager denied it. I then filed an appeal, as well as a notice that the execution, there was a stay of the execution because of the chapter, sorry, I don't have the chapter here, but the documents can be reflected at RA volume 5 and RA volume 6-3. Basically, at that time, for whatever reason, the docket doesn't reflect those documents being timely filed. However, I did also have an email correspondence with John Dolan. He was the assistant registrar at the time, and his email of 5/26/17 confirms that my paperwork was filed, the appeal was filed, and the notice of stay of execution was timely filed. And you can find that at RAV I4-15. And as I said, for some reason, it didn't get docketed. There were some additional actions. I assumed at this point in time, the court was going to compile the record so that I might be able to proceed in the appeals court. And it didn't, but there were apparently some other documents that Justice Meager issued saying there was no appeal on record pending, and then she issued the execution. I perhaps should have been a little bit more forthright and visited the court, but I assumed that the court was just simply working to compile the record so that I could file the appeal. When a substantial, like about a year passed, I went up to the court and I double checked and found after I had received a correspondence from my former spouse that these documents had been filed. I confirmed that it was. Then I was wondering why all of this had happened. So there are a number of documents that I filed with the court requesting confirmation, requesting the court to review the documents, order the appeal to proceed. I corresponded with the registrar of the office and no response. I did.
Was your appeal of the contempt judgment ever assembled? The record?
It was out in 2019, but it came about after another document that I filed, which was a request specifically for Judge Meager to review and to
wait, when in 2019 was the record assembled?
At the end of 2019.
Do you have a date? I don't see that anywhere on the docket.
I do. Well, it may not be on the docket, but it certainly happened because we wouldn't be here in this appeals court. I can get that for you.
That's not necessarily true. That's why I'm asking the question. I have the docket in front of me. I don't see anything in 2019. There's an assembly of the record on January 14th, 2020, and that's of the motion for reconsideration denial. I don't see a record assembled on the contempt, so I just need you to help me with that.
Okay, I filed a notice of appeal, Your Honor, on 12/22/19, and that's,
Hold on, well, that's not docketed.
I know that, but it's here.
It's docketed on January 8th. Is that the one you're talking about, paper 421?
It could be, Your Honor. I'd have to look. But it's in my exhibits is volume 5-37.
So what is the January 2020 notice of appeal? What are you attempting to appeal there?
At that point, I was filing an appeal because I had made the motion under Rule 60 to Judge Meager for her to vacate her orders of in 2017.
Okay, so where is you said there was the record was assembled in 2019 on the judgment on the contempt.
It was on the, well, what it was basically a notice of the appeal. I was appealing the Judge Meager's Rule 60 because of.
No, I definitely understand that. You have filed a notice of appeal of Judge Mahar's 60B decision.
Yeah.
What I'm trying to figure out, and I apologize, it's just a very long docket. So if you have it at your fingertips, it would be super helpful. When the record was assembled for the May 2017 judgment, where she said you hadn't paid the money, but didn't have the assets to actually make the payment, where is that notice of assembly?
Sorry, I'm looking.
That's okay. You filed your notice of appeal on that. It was dated May 19th, and then it was docketed May 26, 2017. That's paper 411. After that, I don't see the record being assembled except for the 60B motion.
Yes, you're correct. That's correct.
Okay, thank you.
That was my concern, and I was sitting and waiting for it to be compiled because I had filed the appeal, but didn't see the following documents that the justice said that there was no appeal, and that I'm not
sure that the contempt is actually before us. I want to just sort of warn you about that. We're going to take a deep dive into the record, but if that wasn't assembled, I don't know that that's before us.
Okay.
It may be that the only thing before us is the appeal of the 60B motion.
Okay.
Okay.
And so
but please continue with your argument. I'm sorry for interrupting.
No, that's okay. I mean, basically, the Rule 60B motion asked her to reconsider all of what was done in 2017. Therefore, that was what I was appealing, the fact that she refused to vacate those orders. And basically, I know that Counsel for Farnsworth has indicated a reasonable amount of time is due for filing such a motion, but that is also true to, there are other case laws, if I may, that actually expands that, because his argument is a reasonable amount of time might be something like about a year or so. But there are two cases that show no time limit for the appeals. One is Crosby versus Bland Street Co., which was 312 Fed 2D 483 Second Circuit. And it said it voided the earlier execution and the order, and it was 30 years later. Also, Marguerite Corp versus Preister, 234 Fed Sup 799, D5C 1964. The court held that.
Did you cite those in your brief?
I did not, Your Honor. I can submit if the court would allow me leave to provide those cases. If
you gave us the cites, that's fine.
Thank you. So that particular one held that there was no real time limit, so that there is argument that's to determine what is reasonable. in this situation.
Just ask you, what was the nature of the hearing that was held on the contempt complaint?
The nature was Mr. Farnsworth was stating I needed to make payment against a judgment. And basically, I had just gone through a bankruptcy to show that I had no assets.
So the parties appeared before the judge and made arguments. Was that what happened at the hearing? Was there any testimony taken at the hearing?
Very little. I pointed out that there was 266,000 and change that was not accounted for since we had last been before the court.
Were you sworn in when you told the judge that?
Yes, ma'am. Yes. And I also went on record asking for a full evidentiary hearing, and I had a motion for an accounting pending. Also, attorney John Anastasi had been appointed a receiver, and he has not ever to this date filed any accounting whatsoever. And
I see your time is up. Let me just see if any of the other judges have any more questions. I don't see any. So Ms. Farnsworth, thank you very much. If you could put yourself on mute, and now we'll hear from Attorney Smith.
thank you.
Thank you.
Good morning, Your Honors. May it please the court. My name is William Smith, and it's my privilege to represent Mr. Farnsworth in this matter. Your Honors, as I argued, sort of as the threshold argument, understanding, I'm not suggesting, of course, the due process. The appellant sort of prefaced her remarks today by saying that, you know, her case is based on due process. I'm not suggesting that's not important, but the fact of the matter is that, Your Honors, that her brief is devoid of any actual full explanation as to how this violated due process. I mean, and I don't know whether there's anything in the case law that draws this distinction. I think lawyers, as well as pro se litigants, are required to adhere to that standard. The appellant is actually also a former member of the bar. So I would suggest, I believe in her brief, she cites to one case, is my recollection. I think she's saying that the cases she cited today deal with Rule 60. I don't know. Obviously, I have not read them. She didn't raise them in her brief, Your Honors.
Well, Attorney Smith, why isn't she entitled to an evidentiary hearing on the complaint for contempt?
I believe there was one, and I think she said that there was one. The problem is, in her appeal, she has provided nothing. I mean, it would be her obligation to produce the transcripts from that hearing. What she is saying is that the hearing was held, and then she filed this, apparently, from all I can see, it's a memorandum where she made the claim after the fact, after the contempt hearing, made the claim that there was some 200 some odd thousand, in somewhere north of 200,000, that she had in fact paid, which
I thought I saw that in an answer to the complaint, that there was a partial payment. Maybe not. Am I misrecalling?
I mean, my understanding is she filed it as a motion in the auspices of a motion to reconsider, Your Honor. But regardless, she has not pointed to anywhere in the record. She has not produced the transcripts from that contempt hearing, nor has she cited to anywhere in the record that would indicate that Judge Maher, abused her discretion, acted erroneously. And I would suggest that's why it's especially critical in these proceedings. Even to ascertain whether it was simply legal error would be difficult enough to do without actual citation to somewhere in the record. But I think it's especially critical in these probate court hearings, trials, and then appeals, because of the fact that, of course, the standard of review is almost completely different as to virtually every issue. So she has not made any showing that Judge Maher abused her discretion or acted in any way erroneously. I mean, the fact of the matter is, the judgment is what it is. Judge Maher carefully considered in her findings. She made very specific findings
Let me
saying
interrupt
that,
for a moment, Attorney Smith. You would agree that that Ms. Farnsworth has provided to the court some evidence of numerous attempts to have the record assembled that just went unresponded to. Correct?
I don't know that they were unresponded to. I think her argument is that there was a delay. I think she says there was some 2 years, perhaps a little more than 2 years of a delay. But of course, the case, I'm
So
sorry,
the
Your Honor.
fact of the matter is that it would be unfair to punish Ms. Farnsworth for failing to provide the assembly of record when she's requested it over time and it hasn't been produced. But it's my understanding that your argument is that her appeal is limited to the 60B. So I'd like to hear what you have to say about that.
I think that is one way of looking at it, and I would suggest she is beyond that. I mean, she's beyond the rule. The rule only allots that amount of time, and she's beyond that. But regardless, getting to the merits of it, all she has done is to make the blanket argument repeatedly that her due process rights were violated, and that's not enough. She has not explained exactly why, and nor has she provided any citation to legal authority to support that proposition.
The judge orders the execution issue in the full amount of the judgment. I'm looking at her supplemental answer to the complaint, and it does say that she made a partial payment in the amount of $266,988. And then the answer does request an evidentiary hearing. So before an execution issues in the total amount of the judgment, wasn't she entitled to an evidentiary hearing?
And she was given one. There was a contempt hearing, and as she just stated today, they had a hearing, and she said there was at least some quantum of testimony lost.
So the judge didn't issue any findings on that partial payment, right? I mean, it just says she owes the
Correct.
intentionally failed. So, I mean, how do we know what if the judge even considered it?
Correct. And I think, as I said it in my brief, Your Honor, I know at least one or two cases where this court and the SJC have held that in the absence of any such specificity, the appellate court can and should assume that the judge simply did not credit it. I mean, if there was that amount that was in excess of $200,000, then presumably that was in fact presented at the contempt hearing. And Judge Mahart did not.
My point is, Attorney Smith, is that if we're looking at the merits of both the contempt and motion for reconsideration, given that evidence, it's all conjecture because we don't have the record assembled.
Correct, Your Honor.
How do we get to the merits of the case without the record?
Correct, Your Honor. And it's the appellant's burden to produce that record, and she has not done so. So, I mean, it's respectfully, Your Honor, I think the case law makes it very clear. It certainly is not my client's burden to produce a record to rebut arguments that are unsupported by a citation to a transcript, because the transcript wasn't included in her appeal.
Attorney Smith, you made several arguments in your brief. Tell me which is your strongest argument.
As to what argument specifically, Your Honor?
As to why your claim is that the appellant's motion should be denied, correct? Just generally.
Correct.
Tell me what your strongest argument in support of that is.
Well, the judge, she filed a motion to reconsider as a threshold matter, as I cited in my brief, Your Honor. I don't see that there was a notice of appeal filed of the denial of the motion for reconsideration, for one thing. But even putting that aside, let's assume for the sake of argument that there was, and that is properly preserved, perfected. Your Honor, I mean, she has, I guess the crux of her case, I think, is this $200,000 that she says, I mean, what her argument is in sum and substance is that Judge Maher was somehow compelled to find that credible. Yet she has not produced any citation to a record. She has not produced a transcript. She has produced nothing that would indicate that Judge Maher, considered that, or that evidence was presented at the contempt hearing. And then Judge Maher either, committed legal error or abused her discretion somehow vis-a-vis that partial payment that the appellant said that she made. I mean, I think that my reading of the record here is that what she did was she filed a motion to reconsider. And in that motion to reconsider, she included what I guess you could call a spreadsheet or a memorandum indicating she had made that payment. But again, I'm willing to assume for the sake of argument that was, that was litigated at the contempt hearing, Your Honor. But the fact of the matter is the Judge Maher found that the full amount was still outstanding. And then as to the execution, what the appellant said earlier in her presentation today, she had said that there was no appeal on record. I think she was saying that's what Judge Maher had said. Well, yes, but what Judge Maher was referring to was that the underlying judgment was never appealed, i.e. the underlying divorce judgment from, I think it was 2014, was not appealed. So what Judge Maher was simply saying was, it's kind of neither here nor there. I mean, I can't speak for her, but I think she was saying the execution is kind of neither here nor there because the underlying judgment was not appealed.
Let's say, just for sake of argument, that she did make some partial payment. What recourse does she have going forward?
Well, Your Honor, of course, if she did, number one, and number two, assuming for the sake of argument that was presented at the contempt hearing, which she has not offered anything that I've seen to indicate that it was.
I'm just asking you to assume that she made a partial payment of around $267,000. And so what can she do going forward? Is there anything?
I mean, I suppose she could. I'm really not sure. I think that's an excellent question. I mean, it's been adjudicated. Judge Maher made those findings. She at one point, as appellant correctly pointed out here this morning, she at one point did say that, criminal contempt or that sort of thing would not be appropriate. But it sort of is what it is at this point. And her recourse, if any, was to appeal it here today, including the entire record, which would have been included the transcripts of that contempt hearing, and she didn't do it. So, maybe there is no recourse. That could very well be.
I mean, I
the
think
fact of the matter is she had due process.
Yeah, I understand. All some of the procedural issues I think can't be laid. It's not entirely her fault. But I think what's troubling me is this supplemental answer has an exhibit attached to it, which appears to be some sort of bank statement that does reflect a payment of $267,000. And I'm troubled by the judge's failure to take that issue on head on in the judgment. I mean, if the judge had said, I don't find this credible, that'd be one thing. I am a little troubled by this.
I think it is there in her finding, Your Honor, with all due respect. I think it's implicit in her finding that the appellant owed the judgment, which was the full amount, somewhere around $900 some odd thousand. I think that's implicit in there. And I think the case law makes it very clear in situations like this that, this court, even in situations where there might not be that express or explicit of a finding, it is there. I would suggest in this case it is there. But beyond that, I don't think that there's any requirement for a probate court judge under the law, to say, I find such and such credible, I find such and such not credible. I mean, I have to believe if that payment was at play before
The judge has to credit or discredit conflicts in testimony or conflicts in evidence. If somebody says the light's red and somebody says the light's green, a judge has to decide which one she believes.
Sure. But I mean, again, going back to what I said, though, her finding here, I mean, it is there. She found that no, not the 900 some odd thousand, less the 200 some odd thousand was due. Judge Maher found that the 900 something thousand was due in full. So if that issue was adjudicated, we don't know. We don't know whether it was litigated because the appellant has not provided the transcript from that hearing. So we don't know. But I think the case law makes it very clear that in a circumstance like this, as I cited in my brief, that the appellate court is to basically to conclude that the judge considered it, and that was her finding. She did not credit.
We have documentary evidence in our record that at least based on what we have does seem to support her claim. And, so we're just supposed to assume that the judge, I don't know. I mean, what are we to assume?
Well, I mean, the appellate court can't assume anything. I mean, as this court says over and over and over in cases, that is an adjudication to be made by the trial judge, and that's what
we're supposed to assume that the trial judge made that adjudication implicitly. So she rejected the documentary evidence, or she found, in fact, that disbursement was not what it was represented to be. I mean, it's really hard.
Well, she, again, I would just go back to, she did find that the entire amount remained outstanding, and I cited in my brief, I mean, I'm just looking for it here. It's in my brief. I apologize. I forget exactly which cases they were. I mean, but this court has said that is what an appellate court is to do in this circumstance. Again, I mean, if this was in fact at issue, and if it was presented at the contempt hearing, I would think an appellant would include all of that in his or her record appendix, and that wasn't done.
Are there any open proceedings right now in the probate court on this case?
Not of which I am aware, Your Honor.
Okay. It looks like your time has expired. Let me just check with my colleagues. I don't see any additional questions. So thank you both for your arguments. The case is
All right, we are live and on the record.
Okay, once again, it's now good afternoon, everyone. My name is Amy Blake. I am joined by Justice Suk-Young Shin and Justice Maureen Walsh. We are your panel for this case, which is our last case of today's sitting. The case is docket number 2020P1142, LEILA KOEPP and another versus Carol Simon and others. And with that, Mr. Lawler, when you're ready.
If it may please the court, David Lawler on behalf of the defendant appellants, Stephen Simon, Helen J. Simon, Jesse Simon, both individually and trustees of Silverstone Condominium Trust, and Carol Simon also individually. This case comes before the court after a bench trial that occurred on September 11, 2019 in Barnstable Superior Court. And the underlying facts of the case are fairly simple. It involves two pieces of property on Beach Road in Orleans, Massachusetts, a beautiful spot. The first road owned by the plaintiffs, the Koepps, and I hope I'm pronouncing that correctly. That's the road that abuts 26 Beach Road, and it is right on the road. And behind that, a landlocked or would-be landlocked parcel owned by the Simons at 24 Beach. And that 24 Beach Road is accessible over a road through its own property, but also an easement, a pertinent easement going over the 26 Beach Road, the Koepp's property. And that's existed there for years. You go back to the title deeds back in, I think, the 40s or whatever. And the relevant facts here with respect to this road is that the Koepps purchased the property in the late 80s. And at that time, there's some testimony, and I think it's pretty clear that there was a lightly paved asphalt road or road material going over the easement from Beach all the way into 24 Beach Road. And that sometime thereafter, the Koepps constructed a garage. And when you're entering the property, it's on the right-hand side from Beach to 224. And that in 2014, the Simons approached the Koepps and indicated that they were going to repair and replace the road. And as is with many people on Cape Cod, they don't spend the winters here. The work was done when they were gone. And when they came back, that's when the problem started. They were not happy with the construction, the appearance or otherwise, the neighborly relationship, which had existed quite well, pretty much came to an end at that point in time. And the real issues here, Your Honors, is that there's two main issues. There's findings of facts that were inadequate, and there's rulings of law that are simply wrong and otherwise misapplied.
So just
And we understand
that, Counsel, you're not saying any of the findings are clearly erroneous. You're saying that they're
inadequate.
They're lacking.
They're lacking, inadequate. Yeah, we understand the clearly erroneous standard, and we're not attacking that. It's a bench trial. I wouldn't be here if that was the case. What we are looking at, though, and I want to point out that in the case of Rapp v. Berry, that going along with the clearly erroneous standard goes an extra burden to the judge. He has to be very clear and specific with respect to the facts. And the case actually says that, in Rapp, finds that findings must, and he uses the word must, which is very important. The findings must contain as many subsidiary facts as necessary to allow the appeals court or the reviewing court, as language is used, to understand what steps the trial court judge took. And I suggest to you that I cannot, and this court cannot reasonably determine what steps were taken based upon the 14 facts as laid out in the decision. And that he must do this for each fact and for each issue before the court. And it's just simply go through the facts. There's 14 of them. And if you look at the decision, the first two deal with the parties. The second two, number 3 and 4, describe the easement, okay? The fifth one.
Attorney Lawler, can I interrupt for a moment?
Yes.
And we've had an opportunity to review the judge's findings.
Okay.
But this is what I would suggest a relatively simple case about grading and condition of this driveway or road easement. What more needed to be said?
He never talks about grading, and he never talks about the condition of the road when the grant was provided. If you look, Judge, in his decision, the only correct case with respect to the trial court judge that was cited is the case of Gillett versus Livernois. I mispronounced that. And it talks about the dominant estate holder of the easement may not make changes to the easement that burden the serving estate to a greater extent than was contemplated or intended at the time of the grant. At the time of the grant happened in the 40s. Fact number, I believe, fact number 6 talks about that Steve Simon complained about the issue with the builder. It doesn't say what he complained about, but what the facts in the trial talks about is he complained about compaction. He complained about the road being offset. He complained about the grade changing as a result of the construction.
Why is that? Why would that be relevant? I mean, so you say that you're challenging only the remedy ordered by the judge. So how are those facts that you're saying the judge didn't find relevant to the issue of remedy?
Because if the compaction occurred after the grant, we don't know, it was compacted. So that lip would not be nearly as egregious, and it would allow for even an easier cure than was provided. And when you get into Shapiro and the balancing test, and that's really also what you look at, there's no facts indicating that there was any balancing test conducted by the trial judge. All
What
he
is
did
the
was say,
cure? What is the cure that you're saying the judge should have ordered?
well, certainly that he should have certainly explored and indicated as to whether, with respect to fact finding number 11, the defendants have offered to put a cement grading rather than fill where the plaintiff's existing driveway, on which there is no easement, meets the driveway at issue and into the plaintiffs have rejected that improvement.
Right, but as a matter of law, how can the judge order a remedy that goes beyond the boundaries of the easement?
That does
That's
not.
what I'm struggling with.
The cure does not go beyond the bond. 11 does not go beyond the boundary. Those are cement bounds that run from the lip to the boundary edge. And the judge did not explore that and did not say whether that was reasonable or not. He essentially said the plaintiffs rejected it. They're the owners of the subservient estate. It's almost a switching of roles in that regard. And if you read that, the defendants have offered to put a cement grading rather than fill where the plaintiff's existing driveway meets the driveway at issue and into the. I believe that reads that the offer was. I wasn't the trial attorney, but my understanding of that was that new offer was the cement was going to go up to the line of the easement.
It says into the garage driveway. That's not part of the easement, right?
Meets the driveway at issue.
What does that mean? And into the
well,
garage
and into the
driveway?
the plaintiffs have rejected that improvement. Meets the driveway into the garage. I think that part of the garage driveway is also within the 20-foot easement. And I could stand corrected, but I do not believe I'm wrong in that issue.
But Attorney Lawler, isn't the judge entitled to have the plaintiffs in this matter have a driveway that's returned to the previous height and appearance?
Well, certainly there's no case law that talks about appearance. I mean, no, if that was the case, anybody who owned a who wants a driveway going through their property, any particular subservient state would have the ability to complain about the appearance. I had a lawn there, now I have a driveway. I mean,
no,
that's
instead
not
of
the
a
case
partial
law.
fix, aren't they entitled to a full fix of the issue?
Well, but the question comes down to, because when the judge didn't apply the correct standard at the time of the easement, those facts were taken into and they were mentioned, just off the cuff mentioned, that Simon complained to the builder of the garage. Well, if you get into the facts, as in my brief, those complaints were that the grade was changed from the grant to the time when the garage was installed. So we don't know from the judge's decision as to whether or not he found those to be credible or not credible. And I would suggest he found them credible. The only incredible testimony he found was in paragraph 13, where he disregarded the plaintiff's damages claim and found the testimony to be incredible. I think by implication, anything not found incredible would be deemed credible. And that is that this compaction occurred and that essentially the cement trucks and other trucks building the garage changed the grade and lowered it. So essentially, Simon just corrected it to where it would have been, but for the construction of the garage. And the judge made no findings in that regard. He balanced no equities. He completely ignored the standard in Shapiro, where the benefits and conveniences of both parties must, again, the word must be taken into account. And again, that was completely ignored.
Was there evidence about what the grade was prior to the construction of the garage?
Well, the evidence was that it was, I don't believe that there was engineering evidence, but there was evidence by Simon, which again was noted by the judge, just kind of off the cuff, that there was complaints about it. And the testimony in my brief indicates that Simon will say that the level of the pathway changed to the right and slanted down due to what he believed was compaction from the cement truck. I mean, I don't know what a cement truck weighs. I'm not gonna, but I'm guessing I can take into account it weighs quite a bit, and can do damage to these soft Cape Cod roads. And that's really the issue here is that based upon these 14 findings, this court really can't tell what steps he made. It looks like he just said, well, the plaintiffs don't like it. They don't like the appearance. They're a little inconvenienced, and therefore we're going to make them change it. Well, that's not the case law. The case law is there must be a balancing act. And then the judge goes ahead and cites Taylor versus Martha Vineyard Land Bank. And he goes on and on in the rulings of law about that case. And that case has nothing to do with this case.
No, I agree with you that Taylor isn't exactly on point, but what is the remedy that you're saying the judge should have ordered?
I think the judge should have looked at the balancing of the equities, and I believe that Simon came up with some solution that did not invade the plaintiff's land, that could have resolved these issues or taken into account the grade and taken into account the grade that pre-existed the garage. And taken
the
into
garage
account
was built in 1996.
Correct. And the grant was provided in the 40s. And the road was deteriorated and finally changed. The evidence was provided that my guy Simon had to go in every year and fix potholes and do everything. The judge never
your argument is that your clients had the right to go in and restore the driveway to what they believed existed in the 1940s.
Well, certainly the grade.
What
I don't know. I mean,
grade?
it was never determined by the judge. The judge needed to make a ruling in that fact and didn't. He applied the grade as it was in 2014 after the garage. The garage went in later. I mean, the road was there first and then the garage came second. So back in 96, whatever changes.
Are you asking us to send it back for additional findings, or do you want a new hearing?
I mean, I would send it back to additional findings, but that's impossible because the trial judge is retired.
Oh, is Judge Fishman?
Yeah.
Oh, okay.
Yeah. So I wanted to be clear. I don't want to be.
Thank you. I appreciate that.
Yeah, because I mean, obviously, that's impossible at this point. So we'll have to go back. It was a 3 or 4 hour trial. This is not a bench trial. So there's not, as Your Honor indicated previously, the issues weren't fleshed out enough to for the trial judge to make a reasonable conclusion. And then again, and Your Honor indicated, about Taylor, but you can't when the wrong law is provided.
No, but the judge cites the right law earlier, and in any event, we're reviewing the questions of law de novo. So I want to, before you run out of time, I really want to get specific about the remedy, which is what you're saying you're challenging. And the judge, I mean, it's pretty general what the judge ordered. So there are two parts. So the first part says that your clients are to replace or repair the driveway in a manner such that grading extending beyond the easement is not necessary. You don't quarrel with that, right?
I believe that if those cement
grading extending beyond extending beyond the easement, you would agree.
I understand we can't go beyond the easement. Yeah.
Okay, all right. So you don't quarrel with that. So what you're quarreling with is the part of the order that says shall replace the driveway in a manner such that grading beyond that existing prior to the construction of a new driveway is not necessary. Is that what you're quarreling with?
Yes, Your Honor. And I think that some type of remedy just between where the road ends and the easement. And I hope I'm not wrong with the facts. I can see David. But I also just think that the court can't, that the judge was not just the remedy, but the decision that he didn't apply the balancing test, which would indicate that, what work was required by Simon is necessary compared to this alleged inconvenience of the of the plaintiffs, of the Koepps. You're muted, Your Honor.
Didn't want to cough on you. Judge Shin, I just wanted to make sure you're all set, although his time is okay, and Judge Walsh is okay. All right, Attorney Lawler, thank you very much. Attorney Reed, when you are ready.
Thank you, Your Honor. May it please the court, David Reed for the plaintiffs, LEILA and Stephen Koepp. I appreciate the court's focusing on the issues. It is clear that there's no real dispute about what the fundamental law of easements is in this case. We both cite the same premises in the same cases. The issue, as is often the case, is the application of those principles to the fact-sensitive nature of these circumstances. It's clear that over time, this easement evolved. And to be clear, as the plan shows of the plaintiff's property, it is essentially the plaintiff's driveway in which the defendants have been granted easement rights. The plan, I believe it was in 1970, that is of record and in the exhibits, shows that at that time it was a dirt driveway. At some point after that, it was paved with macadam, as Mr. Lawler has indicated. We don't know when that happened or who did it, but apparently it was satisfactory to everybody. And at some level, that macadam deteriorated over time. But the judge found, based upon undisputed facts, that the solution that the defendant had for their opinion about the status of the driveway and the sufficiency of the driveway was to raise it with a concrete bed that prevented the plaintiffs from getting onto and off of their own property and prevented them from getting into and out of their own driveway. Those are stipulated facts prior to trial in the appendix, page 22 and 30, paragraphs number 7, 8, and 11. Those were agreed to by the defendant as facts prior to trial. It is also agreed to prior to trial in the stipulated facts that the easement is no more than 20 feet wide, although the original grants, I'm sure you noted, did not mention that. The width is shown on the plan subsequent to that. And it was agreed by the parties that 20 feet was the maximum width within which the easement could be exercised. And it is also an agreed fact prior to trial and testimony presented at trial that the earthen ramps, which we characterize them as, which the defendants constructed in order to accommodate the plaintiff's access to their new driveway, extended approximately 17 feet beyond the edge of the concrete driveway into the plaintiff's property, into their driveway to their garage, into their driveway into their backyard, beyond the original 20-foot original easement, 20-foot maximum width of the easement. The judge found, based upon those undisputed facts, and for which testimony was also offered at trial, that that increase in the height of the driveway over what existed prior to the construction in 2014 unreasonably inconvenienced and burdened the servient estate in the exercise of their right to use this driveway. It was not an exclusive easement. This was as I've characterized it, their driveway in which the defendant had a right of way. And he also found that the defendant's solution to that increased height was to create either earthen or concrete ramps that would accommodate the plaintiff's access, which they testified they found to be inconvenient because of the height and the grade that it created. There are photographs of the vehicles trying to maneuver over these grades. To shorten them would have made them even steeper, by the way. But he also found that, as one of you just pointed out, several of you pointed out, that to do so, as the defendants proposed and as existed at the time of trial, was not a permissible solution because it went beyond the width of the original right-of-way of not more than 20 feet. Clearly, the judge misspoke in citing the Taylor case for that proposition. It does not stand for that proposition. The Taylor case clearly deals with extensions of a right-of-way or an easement to additional land beyond the dominant estate, not to extending the easement within the servient estate. But the judge reached the right result, even if he stumbled along the way in writing his reasoning for it. And I think the case law is clear that upon review by your court, if the judge reached the right result but stated the wrong reason, that is a harmless error at worst. I submit that.
How do you respond to your brother's argument that the judge didn't make adequate findings and didn't adequately balance the interests and come up with the remedy that would not, in fact, extend beyond the easements?
I don't think the defendant offered any other solution at trial. And as I point out in my memorandum, and as the judge points out in his decision, the defendant had the burden of proof at trial.
So this solution that's referenced in finding 11, that's not what that your brother pointed out. That's not a solution that would stay within the confines of the easement.
The testimony at trial was that substitution of a concrete ramp within the confines of the original easement was not a workable solution, because if it had to stay within the 20-foot original easement, there would have only been a very short horizontal run for such a ramp, and it would have been even steeper than what was there now. And the plaintiffs testified that for their own reasons, as well as for physical reasons, it just wasn't possible to traverse even the longer ramps, never mind a shorter and steeper ramp. There was direct testimony that that was not a workable solution for the plaintiffs, that it would not have been passable and certainly not convenient to them, and would have imposed a greater burden on them, the servient estate, than was originally existing prior to this work being done. So it is our contention that the original principle, excuse me, let me go back to one other point, if I may. The plaintiffs, excuse me, the defendant's first legal argument that if the court made insufficient findings to support its decision, then this court may either make additional findings or remand for additional findings of fact. But I suggest that they don't satisfy the threshold of their own argument. I think the facts found by the judge are fully supported by the evidence and do support the result reached. The trial judge is not required in his decision to explain why he did not find other facts that might have been true, that might have been presented or might have been proffered by the other party. He's not required to explain why he did not accept somebody's testimony or why he did not credit assertions or theories espoused by the other side. He did make the fundamental findings, the essential findings, that what was changed prevented the plaintiffs from using their own property and their own driveway, that the solution that the defendant offered was unacceptable to the plaintiffs and inconvenient to them and beyond the authority that the defendants had under their easement. The solution was to restore it to what it was prior to the 2014 work. I think that is perfectly a reasonable and justifiable solution without having gone back to what it was in 1948, because clearly what it was between 1948 and 2014 was not the same. There had been changes either by one, accepted by the other, or mutually made over the course of time to bring it to what it was in 2014. As for the fault, if there is such a thing, for the change between 2016 and 1996 and 2014, that's an 18-year span within which there was testimony by both Mr. Simon and by Mrs. Koepp that the Simons never complained to my clients about this alleged depression of the ground near the garage. They never sought to make any other repairs or changes to that area prior to 2014. And I think the judge would be entirely reasonable and permissible for him to discredit that argument after that length of time with no action having been taken or proffered by the defendants to this alleged problem. I think he was perfectly justified in accepting that whatever existed in 2014 was the baseline from which he would judge the changes made after 2014. And for that reason, we feel that the judgment, while not as clear and succinct as to exactly what he wanted to be done as we would have hoped, I think it is a workable solution that the defendant's going to have to figure out a way to do, because that's what the judge ordered, and we feel that it is supported by the law and by the facts. Thank you, Your Honors.
Seeing no further questions, we'll take the rest of your argument on your brief. Counsel, thank you both very much. The case has been submitted, and this does conclude today's sitting. I'd like to thank the court staff for their assistance in making this Zoom argument possible.